Yeah.
But that,
Yeah, we'll talk.
that's the annuitized.
Okay.
Cash option at like, probably like $600.
All right.
And you do take a third.
Michael wants it because we have that tax break.
No.
Okay. All right. Well, okay. Well, we're starting up, so I gotta go. All right. Okay. Bye-bye. Oh, okay. You want to go get it?
No. Yeah, I got it.
I hope that cell phone doesn't burn in the
No,
car.
it's in the machine.
Okay.
I'll park them in the-
Or like shade tree mechanics.
I'll park in the garage.
Oh, okay.
In the shade in the garage. Yeah. I thought somebody coming out, so I waited.
On this side?
The old apartment.
Oh, are you in the new garage?
No.
They haven't moved you?
I know.
That's so weird.
It is weird.
No, I'm so feel for it. It's crazy.
Do you
Plus
want-
Michael? Yeah, Michael.
Do you want the new one?
He emailed me about it.
You need to ask.
Okay.
Yeah, I think they overlooked you.
Microphone.
They keep moving like a bunch of people.
You
Okay.
you were already?
Yeah, we all are. We all like it.
You don't have to deal with all the germs.
All right, everyone. Today is Wednesday. Let's keep it a Wednesday. Let's not try to turn it into a Monday. So we're going to start jury selection at 1:30. So we do have this 1:30 docket. And on the 1:30 docket is, I'm sorry, on the 1 o'clock docket is Alexis Morganfield. Where's your client?
My client, Your Honor, is not here. I've also contacted Alberto Cherez, or however you say it, and I've not heard back from him either. Both of them are supposed to be here.
All right. So the way I see it, it is 1:01 p.m. When Mr. Morganfield comes in, take Mr. Morganfield into custody. Omar Madison.
He's present in the box, Your Honor.
All right. And we have Alberto Flores.
Yes, he's on the way.
All right. We're starting up with jury trial at 1:30, so please confer with whomever you need to confer with. And here's Albert Charles. Hello, Mr. Charles.
Hi, Judge.
Hi. Hi, Mr. Morganfield is not here. Did I see the file on Morganfield?
I think-
Yes.
For Morganfield, we have 1 minute.
Okay.
Just FYI. It
All right,
could be
well.
hopefully quick. If he
Okay.
shows up.
No, sorry, do you have the VR report on Morganfield?
Should be in there. The doctor the other day, right?
Yes, it was.
So I can be there. I think it's more.
All right, thank you so much. I appreciate that.
You didn't sign it, right?
No, I did not. Well, I had signed it because he hadn't showed, and then we erased it since he showed late.
Okay. She's checking out where he is.
Thank you.
It's on the GPS. Yes, I'm scared.
Okay. All right, thank you. All right, and on the jury trial case, Saxon, how much time are you all asking for voir dire?
I think 30 minutes would be sufficient. 30 minutes.
Okay. And which case are we proceeding on?
The older case, Judge, the full family second. The 2019 case number.
All right, and in regards to that, of course, we'll start testimony tomorrow. And we'll start testimony tomorrow at 1:30
Okay,
because we have docket in the morning.
we only have 3 witnesses, so I think we might be able to even get it done. Potentially more.
Okay, and then if there's any video or something that I need to see beforehand to make a ruling on, please let me know. That way I can watch it.
Is our.
Yeah.
Okay.
All right, so if there's something you can't agree on, just let me know, and what we'll do after we do jury selection, that'll give me a chance to look at it and I can make a ruling on whatever.
Okay, very good.
Okay.
And I did file a very, very boilerplate pre-trial motion eliminating for like offered stuff, testimonial hearsay, prior bad acts, all that kind of stuff. I don't know when we would take that up either.
All right, well, what I always tell the state is just approach before they get into
Well,
anything.
there's just one thing, it's priors, it's just all family second, so I have to prove that prior, but absent that, I will approach on anything.
Oh, okay. All right,
He left his home at Selma at 12:50. But I don't know where he's going. It's just his own stuff.
okay.
So he might be here.
All right, thank you very much.
Morgan.
Well, that's supposed to be here by one.
Well, he left at 12:50 from his house.
So it's like 1 o'clock on the. It doesn't say be here at 12:30 when you want, it says 1 o'clock,
He's on the way.
that's the difference.
Yeah, no, but he left.
He did acknowledge breaching the law in front of the board and board officials and.
Seems like
Heard me
he must
saying
have
that.
put the wrong time on. Sorry, I'm seeing.
You're already talking to Saxon, the jury's on all.
Sure. And if y'all would like to use the courtroom or the jury room, just let us know. Would you like to use the jury room?
Sure.
All right, could we open the jury room for them?
Did you call out your election?
No, we still need a judge, we still file our election and our application.
Okay.
And your application is raising right all over there.
It's in the.
Do you want?
It's in the back?
Yeah.
Oh, great, thank you.
There should,
The clerks usually have it.
let me see, I'll try to get them for you. I'll take it back. They're going nothing. Oh. I looked at them. Do you have it? He needs one.
All right, and then, Norma, could you give me the file on Saxon, and it will be the Salt Valley separate case? Thank you. Yes, could I see the file on Omar Madison, please? All right, who are the parties on Omar Madison? And Mr. Madison, if you can come forward. All right, so where are we on this case?
Judge, the last setting, one of the things we came back today was to do a discovery acknowledgements, which we've executed this morning or this afternoon.
All right, thank you.
And Marcus is working on some issues with a witness on the case, and I think the state needs to get a little bit more time to do it.
All right, what are the issues? Because I'm still trying to figure out where this case is going.
I hope it's going towards a dismissal. That's kind of the conversation I had with Marcus, but I don't know that the case can be proved. He was looking into some things. There was an allegation that was not observed by anyone. And the alleged complainant in the case is a disabled individual who can't communicate. And Marcus was trying to get hold of some of the people at the hospital.
All right.
Talk to them about.
Did he tell you, or give you some idea how long this is going to take?
Judge, I just spoke to him on the phone. He said he's called the lady continuously and she hasn't gotten back to him, so he was requesting just a 30-day reset and go from there.
All right, I'm going to give 3 weeks
Okay, Judge.
because if, they've been calling and calling at some point. we need to
Tipping.
make something happen. All right, Ms. Ferguson, on Omar Madison, can I have a 3-week reset, please?
I don't know. Today and then whenever.
All right, August 18th or August 25th?
25th.
August 18th or August 25th?
Let's do 18th.
All right, so we're gonna come back on August 18th, and at that time, something will happen.
Okay, just-
So either it will be, we're doing a jury trial on that day, and what witnesses we have, what witnesses are not there, they're not there.
Judge, I'm sorry to interrupt. That's on the Thursday, you want to put it on Monday then?
Yes.
Okay, well, on Monday, it's gonna be, the 27th,
No, the 27th.
22nd.
No, we're gonna keep it on the 18th, and then if the state doesn't have what it has or whatever the issue is, then we'll move to jury trial the next week.
Okay.
So
18th.
we're gonna come back on the 18th, and then depending on where we're on the 18th, if there's no disposition, then we'll be coming back that Monday. Okay,
Okay, sounds good. Thank you.
all right, thank you. And Ms. Ferguson will give you a reset form. Are the parties ready on Alberto Flores?
Yeah, it's on the waiver. Gonna be here. I think they're making confusion. I think the notice at 1:30, so he's confused with it 1. So he's on the way to it.
All right, Mr. Norman, was Mr. Flores told to be here at 1 p.m.?
I don't know, I'm just looking about. We put 1:30.
All right,
I can't tell you what that's the you were. Yeah,
yes,
yeah, I have 1:30 here, but I understand you.
all right, Miss Ferguson informed it's 1:30,
You said-
and he made it.
Try to be all organized. Didn't just. I don't know, it's like the time to be organized. It's not true. He said that he was coming down because he wasn't here. He really wanted to be here, but then once he realized, like an experience, he was happy. When it's gonna vote.
This board was not.
You want to see it? I can imagine if I work with water and the street, you know that thing that you put up there? It's really, you need something. You have to have. It's just like the water, it's kind of- Right, I'm gonna be safe.
I appreciate it. No, I have it. I have that.
What did he think?
Why did it eat pigs? Never been there. Anyway.
It's chicken. Yeah, the engineer. Your team will make us laugh.
A year and a half, I'm like,
All right, court is going to call. Brenda, are you ready?
Yes.
Court is calling 2021 CR 1804, 2021 CR 1805, State of Texas versus Alexis Morganfield. And our parties approaching, announce for the record, please.
Michael Villarreal, state.
Albert Chidas for Mr. Morganfield.
Ben Stevenson for Mr. Morganfield on the two aforementioned cases.
All
I
right,
have not seen my client yet today.
okay,
Although he did acknowledge orally in the courtroom 2 days ago that he knew about the hearing today and would be here.
all right. This case was actually scheduled for yesterday. At that time, Mr. Morganfield was late. Defense explained that Mr. Morganfield was receiving phone calls through someone else. And so yesterday, the court informed Mr. Morganfield to return to court today by 1 p.m. as stated by defense counsel. Defense, have you all had any contact with your client?
Just one minor correction. It was Monday, Your Honor.
Oh,
that we
thank
were in
you.
court. I was not able to be here because
Yes.
of things I had to do yesterday personally. I have been in contact with him since. He knows to be here. He guaranteed that he would be here before 1 p.m. today, Your Honor.
All right, state.
Yes, sir. At this time, state would move for a bond forfeiture, a warrant be issued for
All right.
one of the cases.
And each of cause numbers 2021 CR 1805 and 2021 CR 1804. The court is going to issue a judge's warrant and the court will remand him without bond.
Judge, I have a witness here. Can that witness be excused?
Yes.
Your Honor, defense urges that because his trial is so soon, his trial is in 13 days, at least next possible trial date, that he be allowed to remain on GPS partial with conditions as is. I do need to urge that for the record, Your Honor.
All right, thank you. That'll be denied. And just so the record is clear, the court is only issuing that ruling in cause number 2021 CR 1805 and 2021 CR 1804, because that's the cases we are here today on a violation report.
Yes, Judge.
All right, and Sage, you can have your witness excused. Is there anything else from either party?
Nothing further. Do you need us to stay, Your Honor?
No. I mean,
Thank
if
you.
you want to stay and see if your client appears, you can, but he's going to be taken into custody.
Is the trial starting at 1:30?
Yes.
I understand. I'll stay till 1:30.
All right, thank you.
Thank you.
Thank you. And it'll only be in those two cases.
This is one of the two.
Yes. All right, Alberto Flores, what is happening with that case?
You know, state not reach a plea agreement and ready to plead out.
All right, thank you. If you'll go over that paperwork, we may end up having to do it at a break because the jury is going to be out, brought in at 1:30, but we'll take that up today.
Thank you.
Thank you.
Oh, they're done with it.
Oh, okay, then. All right, then we will take care of that. And then could I see the file on Mike Marino, Mario Morales, and Aaron Trevino, please? All right, No, that's the one they're doing the plea. on. That's okay. Aaron Trevino. Okay, all right, Mr. Trevino, come on up. All right, Mr. Trevino, it appears that we're going to be starting a jury trial on Mr. Saxon's case. So your case is not going to go today. All right, state on this case and defense on this case, I'm going to need an acknowledgement of discovery. The court does not have that.
Yes, Ron.
All right, and Ms. Ferguson, what is the next jury trial date available for Mr. Trevino?
September 20th.
All right, so your jury trial date is going to be September 20th. And I will make that your jury trial date and plea deadline date, okay? I know that I previously gave you a plea deadline date on the 26th. But could someone, yes. So I know I previously gave you a plea deadline date on the 26th, but I'll extend it to September 20th. Because there's such a wide gap between your jury trial date and now, okay? All right, so we'll see you back on September 20th. Is there anything else? Do you have questions about anything? No. All right, thank you. All right, Mike Marino. Just 1 second, we'll see where your attorney is. Mario Morales.
He's in the jury box.
All right, Mr. Morales, come on down. All right, what is happening with this case?
All this for trial at 1:30.
Okay.
We're here.
Do you have all the discovery?
I believe so.
All right, state on this case, the court does not have the acknowledgement of discovery, so if you have that, please.
Good, Judge. I'm working on both of them.
All right, thank you. And Mr. Morales, it's the court's understanding that you're still requesting a jury trial, is that correct?
Yes, ma'am.
All right, Ms. Ferguson, can I have a jury trial date for Mr. Mario Morales?
That one on September 27th.
All right, I'm gonna make your jury trial date September 27th. And I'll also make that as your plea deadline date. Your plea deadline date has expired, but I'll give you more time since there's a gap of time between now and September, okay? Do you have any questions about anything?
No, you're not.
On behalf of my client, we object to being reset from the day and urge our speedy trial dismissal.
All right, well, we'll go on the record. The court is going to call 2019 CR 9698, State of Texas versus Mario Morales. Can I have parties announced for the record for the state,
Michael for the real estate.
for the defense?
Anton Hayek.
And are you Mr. Morales?
Yes, you are.
All right, the court will state for the record that Mr. Morales, there is a case that is scheduled for jury trial before yours. And that case is going today, and that is State of Texas versus Christopher Saxon in cause number 2019 CR 10448. And of course, the court cannot have two jury trials at the same time. We only have one jury that's available. And so that the record can be clear, I will state that in Bexar County, we've had a limited number of jurors because of the uptick in COVID. So as of now, we only have 60 jurors available today, this week, for the 187 District Court. Is there something you wish to say, Mr.
First off, I understand the COVID problem, and I agree with what your characterization of it. I object that his case is being reset. He's been in jail for over 2 years. I re-urge our move for a speedy trial. I would ask for a PR bond with house arrest pending the next trial date.
All right, with regards to the PR bond, your client is charged with continuous sexual abuse of a child. The court under cause, I'm sorry. The court under Code of Criminal Procedure, Article 17, Court 15 is not available to issue a PR bond or issue a lower bond in this case until the court has received certain items. And those items would be your entire criminal history. As part of those items, also, I would need to know whether or not there has been a time that you have not appeared in person on your court dates, not just for this case, but for any case. And I would also need to know if there is some history of affirmative finding of family violence or any violent offenses. And the court does not have that to make its ruling. But if you would like, what I can do is I can have you interview for a PR bond, and hopefully I will receive the other information that I need to make a decision.
That would be excellent, Your Honor. Thank you so much.
All right, you're welcome.
And Judge, just for purpose of the record, I'd also like to note that I believe that the defense has requested a motion for continuance in this case, which was granted previously.
Mhm.
And so that part due to that delay, although part of the.
All right, and the court will note for the record, according to the docketing sheet, on April 21st, 2022, there was a motion for continuance that was granted. And that motion for continuance was requested by the defense. So what we'll do, Ms. Ferguson, can you have him interview for a PR bond and then have that forwarded to Judge Carruthers? All right,
Thank you
so
much.
you're welcome. So we'll be
Thanks,
back on, just 1 second, we'll be back on September 27th. That will be your jury trial date and your plea deadline date.
Thank you.
All right, thank you. All right, could I see the parties on Mike Marino, please? All right, Mr. Gebbia, what is happening with Mr. Marino?
That's a wonderful question, Your Honor.
I haven't been able to talk to Bobby yet, Judge.
Okay,
But if I could have just a couple minutes to speak to him.
yes,
Confer about some issues. And if we can reinforce potential.
sure. All right, and then I'm gonna, Mr. Marino, if you'll take a seat, and I'm gonna call Alberto Flores. Is there a prosecutor available to take this?
Yes.
All right, the court is calling 2022 CR 3722, State of Texas versus Alberto Flores. Can I have parties announced for the record for the state,
Brittany starts.
for the defense?
Ryan Berkman.
All right, Mr. Flores, if you can come up. Are you Mr. Flores?
Yes, ma'am.
Mr. Defense, I'm going to show you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes,
Court will find that the state is in compliance with discovery. Mr. Flores, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it? State counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Flores, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yeah.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
No, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do
Yes, Your Honor.
you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. To all of those who are sitting in the gallery, do not take any numbers that you found in your chair with you. Please leave those numbers. Back on the record, I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison and there are no applications. Did you understand that to be the plea bargain agreement? Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Judge, state office states exhibit 1 and all attachments.
Any objections?
No, Your Honor.
Mr. Forrest, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review this document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, it's a privilege to represent Mr. Flotis. He's an uncle to my bone-in-law. He's a hard worker. He's a good man. Just fortunately, he ran into a situation where he was trying to get something to eat in the middle of the night and fell asleep at a drive-through. Your Honor, he's a good person. I asked the court to take mercy on any sentencing that he does have and improve this plea deal.
All right, Mr. Forrest, it appears that you have an alcohol problem because I'm looking at the case from 2018.
That's right.
And there were other charges of alcohol. And then I'm looking at the misdemeanor case. You understand?
Yes, ma'am.
So what it appears to the court is that you cannot drink alcohol. You're one of those people who you can't stop at one drink. And I've told everybody who's appeared before me, and I would tell clients this, I would always tell them, don't drink and drive, because you obviously can't take one drink and drive. It's best just, if you're going to drink, don't drive at all. Take a via bus, ride a bicycle, but don't ride in a motor vehicle. Don't drive a water boat. Don't do any of that. Because what ends up happening, the person usually who's intoxicated, they usually end up causing an accident. And when they do, I haven't done statistics on this, my statistical professor would be upset. But what I found just from my time as an attorney and as a judge, what ends up happening is the person who's intoxicated walks away without a scrape. Usually who ends up getting killed is some person with their children in the car, or either the passengers in the car, the person who's drinking and driving. I'm going to follow your agreement. What I can do is recommend the therapeutic community for you. The therapeutic community will not extend your sentence beyond the 2 years, but it will hopefully help you get on the right track. Even though I recommend it, you still going to have to ask for it, and they still may not give it to you. It's going to depend on if they have room. So would you like that?
Yes, ma'am.
All right. So as previously stated, I'm finding you guilty. I'm going to sentence you to 2 years in the prison and give you credit for any time served. And I'm going to request the therapeutic community. And I don't know how much time you have in. Who knows? They may end up releasing you from the Bexar County Jail. If they do, you need to quickly not shout and be happy that you've been released. You need to head straight to an NA meeting or an AA meeting. And you need to see if your family members can go to Al-Anon meetings or something to help you, okay? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
ma'am.
All right, good luck to you, Mr. Flores, and remember what I said about getting help.
Yes, ma'am.
Thank you, Judge.
Thank you.
Excuse.
Can you have the attorneys in the back? Let them know we're starting up a jury trial.
Oh. Judge, also in that matter, if he has an interlock on a vehicle that the family does use, do I come with a separate order, ask to request to have that removed?
Yes, we'll just speak with the clerks and we'll get it removed.
Thank you, Judge.
Thank you.
Your Honor,
Yes,
I need to make an announcement.
yes.
Within 5 minutes after we were up the bench, the last time my client did arrive and was taken promptly into custody by one of the deputies. So we did want to let you know that he did come. His mom's here. And given that what was said, and given that he was not here at 1, we'd like to know what are the court's intentions, given the fact that he is still on trial docket for August 9th.
All right, we'll make sure he comes back from the Bear County Jail for his jury trial.
Okay. So is it the court's intention to leave him incarcerated between now and August 9th?
Yes,
I understand.
thank you.
Thank you.
And if you need any help with the clothing exchange, if there's some
how
difficulty,
to do
just let us know.
Okay.
All right, sometimes there's some breakdown.
Got
So
it. Yeah,
just let us
I'll
know.
go through the normal procedure for that.
All right, thank you.
Thank you so
You're
much.
welcome. Yes, no, just I'll let the clerks know and I'll put it on the file.
Okay, if I wait on Judge, make sure.
With regard to the last person, Mr. Forrest, we need to have the ignition interlock removed.
Okay.
All right, thank you. All right, everyone, Mr. Gebbia.
We'll be ready in a second.
Okay, all right, thank you. All right, can I see the file on Christopher SAXON, please? Oh, wait a minute. Here it is. Thank you, got it. All right, and defense, on Mr. Saxon, I don't want to interfere with any of your strategy or anything, but do you anticipate calling witnesses? That way I'll know where we're stopping off on Thursday.
We may call one witness.
Okay, so we may end up, and I'll let you all know beforehand, so we may end up going straight into closing arguments. All right, Mr. Gebbia.
I have had an opportunity to confer with the prosecution. Doesn't appear that our case is going to resolve via plea bargain at this juncture.
All right, Mr. Marino, come on up. All right, on this one, the court has the acknowledgement of discovery. So is there any other outstanding discovery?
You know, it's hard to tell. It's certainly possible, but I feel like right now at this point that the state has complied with what it is that they have. If anything else comes up, me and Michael are in pretty constant contact.
And congratulations on your soon-to-be new position.
I'm already in the new position.
Oh, well, congratulations. Are you going to keep this case?
Yes, sir.
All right.
I'm gonna hold on to the majority of my court appointments.
Okay.
And a handful of retained cases.
All right. So, Ms. Ferguson, can I have a jury trial date for Mr. Marino, please?
The 27th. September 27th.
All right, so we're gonna come back on September 27th. I'm gonna make that your jury trial date and your plea deadline date, even though your plea deadline has expired, but because there is such a gap between now and the September date, I'll add that as your jury trial date and plea deadline date.
Yes, ma'am.
All right, is there anything else?
You know, and I'm gonna look a little bit further into it, but we might confer with the state once he gets past whatever he's working on now and talk about maybe some bond relief for Mr. Moreno.
All right, thank you.
Thank you so much. See if I can. do some bond relief.
Yes.
Judge. I could have just a couple minutes to talk to Mr. Slomaine.
Sure.
Potentially it's the movement that I
Okay. All right, sure.
I'm trying to look at. Thank you.
How are you?
All right, how's everything going?
Great.
Yeah. So how are you enjoying your
I like the
position?
flowers.
Oh, thank you.
Might be enjoying it a little bit too much.
Okay.
It's kind of nice, you know?
All right, well, I hope you
Yeah.
won't be a stranger.
I know, I feel like I've been a bit of a stranger, so it's nice to come around a little bit. We're in the old BCIT building or the old elections building. I heard it used to be the juvenile detention center.
Yes.
And then I heard from Chief Judge Barry over in the federal courts that it used to be some type of education center.
Oh,
I don't even remember.
I don't
like, way
remember the
back when some
education
public-
center, but I
public
remember
education
everything
center.
else.
He's like, I used to go there when I was a kid to visit my mom. She worked for the state education center or something.
Oh, wow.
And it's scheduled for demolition, so.
Yeah. So I'll be like, where's your cup of coffee? Because you usually have the,
I had some when I came in.
all right.
I know.
So it's the cup that, it's sort of like a Harry Potter cup.
Yeah,
It
It's never
never,
empty.
it's never empty. And it's like, it's teeny tiny. And I'm like, I know he's
Yeah.
taking a lot of sips out of that.
I have my own coffee pot now, which is
Oh,
great.
wow.
Yeah.
Are you making your own coffee?
Oh,
You have some help.
I got some help on that.
Yeah. Oh, I don't make the coffee either. I just like,
I'll let
whoever's
you go,
making
Judge. You
coffee.
look busy.
All right, have a good one.
Thank you.
Judge, may I approach?
Yes,
I got a message from Mr. Stevenson that the client finally showed up.
yes, he did.
Okay. Assuming that the proceeding already came on.
Yes, so he's going to remain in custody. He does have a jury trial that's upcoming. What is his jury trial date, Norma?
I think he said the night.
Yes, the ninth.
So it's August the 9th.
I don't have mine with him until the 16th and it's a night max still.
All right, well, if you want to show up, because I imagine, and I don't know if they're still gonna have plea bargain agreements. I don't know if their plea bargain agreement has expired or not. So if you can make sure you're here on that date as well, because sometimes they want to say, well, we need the other attorney here as well. And sometimes the client feels more comfortable if both the attorneys are present, even though this case is not the case that's for jury trial.
Right, right. And that's at 9, I'm assuming.
Yes, it'll be at 9.
Thank you, Judge.
All right, you're welcome. Good seeing you. All right. Michelle, could you let them know that I don't want the jury to be outside waiting, to 2 o'clock.
Okay.
They're in the back, I believe, in the jury room.
Okay.
Oh, or maybe they're in the hallways or in the offices. No, I think that's it. So you guys are leaving men behind.
Yeah.
All right, and on this one, we can make sure that on Morganville, it says judge's warrant, because then they'll not have to touch it.
Yes, okay.
All right, thank you.
This one, you wanna say that one?
Ah.
Gonna have 30 seconds.
Yes.
Yeah. But also maybe, like, when the text starts, probably someone who's not doing it. Yeah, I'm just in Dr. Lauren, I mean, just normal paper. It's too funny. Are you kind of enjoying not having it? You're kind of enjoying not having it? I think you're loving going on all day. This one's. But I'm lost without it. It's
All right, and say, can you look into this cost number, see if you have any objection to just terminating them? They completed everything, but they owe fines. And fees.
Yes, ma'am.
All right, are we proceeding with jury trial?
I believe so.
Okay. All righty.
with all this. I think last I had it. Yes, they're having. Oh, they're having. Did Richmond wait for the day? Yes.
No, she headed back.
Yeah.
Judge, would you, this is Miko, he's a law student at St. Mary.
Hi, welcome.
Good afternoon, Your Honor.
He's been shadowing with Andrew for like in our office too, so he heard that we were possibly were going to trial, so.
Sure.
Do you mind, could he sit in Vishwan's chair or
Sure.
somewhere close over there?
So what year are you in?
I'm a 3-0.
Oh, well, you're about to enter the real world. Do you have your student bar card?
So I'm actually working on that right now. Mr. Toilet's signing the papers and then I take him to the dean tomorrow to get signatures.
That would be awesome. I got my student bar card and you know that you get to keep that number.
Do you?
Yes.
I didn't even know it was possible, but I was working
Oh, yeah,
during the
people
day, so
were,
I didn't know about all that.
people
stuff.
always wonder about my number. My number is so easy.
Do you have a
to
cool
remember.
number, like
Oh.
one of the old numbers?
Oh, yes.
What does yours start with?
9.
Oh.
Mine start with 9,000.
Mine's, oh, God, mine's 2411 and everybody's is 2411. So when you hear other ones, it's kind of cool to hear.
Well, oops, excuse me. The other people came out with me, but didn't do that.
Yep. I got it.
All of their numbers are 2,400.
Yeah,
And then
that's
whatever the
all
number
true,
is.
Except for town, that's cool.
I appreciate it.
All right, thank you. And come down anytime. We're always open.
Yeah, I think there's one. Is that my
And then, yeah, I'll take it.
I'm gonna run to the restaurant, I'll be back.
Yeah, just give me a second.
Yeah, she can't really go to trial. Happening. At least with somebody. Oh my goodness. I don't know how to do it. Yeah. Am I in here way?
No, I just want to make sure I'm not pulling something. That it shouldn't.
Or just the questionnaires.
You really want to. Yeah. What's your name? Brenna. Brenna was next. And then.
Oh, I only have this.
Because I thought nobody with the stash. I'll have my phone.
Do y'all have the jury questionnaires?
Yeah, I do.
Okay,
Yes, we do.
okay,
You don't.
yes.
I'm like, you want to go check. Oh, I have one that down number 45. Is that all the dollars? Oh, I didn't have that. But I have that's.
All right, defense, I don't know if you all have ever been through jury selection in this court, but the way we do it is the state will have 30 minutes. You can do specific in voir dire at that, I mean, in general at that time. And then you'll have 30 minutes. I always pick alternates. And also if I then, once you finish with jury selection, I'll allow you all to confer to see what you can agree on and what you can't agree on. I'll make the decision.
Great.
But I don't do a wholesale, we're now calling everybody back in.
I understand.
All right. So we're going to go on the record to make announcements. The court is calling 2019 CR 10448, State of Texas versus Christopher Saxon. Can I have parties announced for the record for the state,
Michael Villarreal and Michelle Hayden for the state.
for the defense?
Nathan Slimane and Valerie Headland.
All right. And are you Mr. Saxon?
Oh, I'm sorry, yes,
All right. And state, are you ready to proceed?
yes, sir.
Defense, you ready to proceed?
We're ready.
All right. And it's my understanding the court is in receipt of the election of punishment, and the defense has sought to go to the court for punishment if Mr. Saxon were convicted. Is that correct?
That is correct.
All right. Deputy Laura, whenever you're ready.
Yes, we have to making sure they're different.
Okay, no problem.
We have a list of any potential people who are not.
Oh, that's what they're checking.
Okay.
We shall see. If we have everyone, that will be the first time we've had everyone.
No, so we have two people, person called number 45. She has a test at school today.
Okay,
So that's my 45. 45 times. 45 and 38 are definitely not here.
okay,
38 has a doctor's.
okay. And you say 45?
Yes.
All right. So state and defense, so far, number 45 is not present, and number 38 has a doctor's excuse.
38 and 45.
Yes.
Do you want us to wait for the jury to come in before we request a shuffle?
All right, that's keeping everybody on their toes. I appreciate that.
Thanks. I thought it was.
Brenna, or should I say it's too soon?
Too soon.
Too soon. Brenna, I still have jokes that I need to tell, and people keep telling me it's too soon. And that's been 20 years. They're like, no, too soon.
Number 30 and 45.
Number three. 45.
Number 38 is still. She's here. Judge number 38 is here.
Okay. So who is missing?
Number 3, Judge, number 11, number 14,
Wait. Okay, number 3.
number 11,
Okay.
14,
Mhm.
and 45.
And 45. So state defense, and we're on the record. The numbers that are not present are number 3, number 11, number 14, and 45. Any objections to excusing those jurors in proceeding? State
No, you are.
defense?
No objection.
38. It's
30.
oh. 38 for me, Judge. Okay.
Okay. All right, if everyone's ready to proceed, we'll bring the jurors in. And the charge, all right, and for the record, the charge is assault family second offense, is that correct? State defense?
Yes, Your Honor.
Yes, sir.
All right, thank you.
Do they can leave the camera? Please.
All right, everyone, please rise.
First row, in the bottom. Take your zone.
Oh, no, please be seated. We're standing for you all. Unless you want to stand to get some exercise in, you can all be seated. All right, everyone, please be seated. Good afternoon, everyone. Okay, that is like weak and low. Good afternoon, everyone. Okay, that is awesome. You're in the 187th District Court. I'm Judge Stephanie Boyd. I know you all were scheduled to be here yesterday. And what I can tell you is that we were in a jury trial yesterday that was finishing up. So in this court, we usually have a jury trial about once a week. And plus I'm handling our current docket as well. So I appreciate you all for coming back. And we had docket beforehand. That's why you are in the hallway. We had cases other than the case that's before you now. So as I said before, I'm Judge Stephanie Boyd. You're in the 187th District Court. It's on the 4th floor. So what court are we in? Which floor? Who's the judge? See, you guys, people always trail off on that last part. So we're going to try this again, and then I'm going to tell you the reason why I do this. So which floor are we on? Which court? Who's the judge? Now, I know you're saying, like, why would she do that? We know where we are. So here's the thing. Whenever we're doing jury selection, if I give you all a break, we can't begin again until everyone is here. And the first jury trial we had in this court, I didn't do that. So we're waiting for a juror. We're like, okay, we gave everybody 15 minutes. It's now been 30 minutes. Where's this juror? So everybody was searching for the juror, and the juror was actually down the hallway about to be picked and selected on another jury in another courtroom. So we had to go grab them and bring them back. And then we had an incident where someone looked up and they're like, I look up and everybody's gone. I'm like, where am I supposed to be? And then they said they remember 187, 4th floor, Judge Boyd, because I'm the only Judge Boyd in the courthouse. To my right, we have the court reporter, Brenna DeMoss. Brenna, can you raise your hand for them? All right, so Brenna is a great court reporter. She can take down 3 people at one time. She has the eyes in the back of her head, but I always try to make people's job as easy as possible. So to make her job easy, we just need people to speak one person at a time. So when the state or the defense has questions for you, you have in your possession what is gold. And you know what that is? Those are those cards with the numbers on them. So if you could you please raise your card for me? All right. So whenever you want to say something, or you have something to, or you're addressing a question that's been asked, or maybe you just want to say something, you just raise that card, and then either the state or the defense will recognize your card number. And that makes it easy for Brenna, because then we only have one person speaking at a time. So this case is the state of Texas versus Christopher Saxon. I'm going to have the state introduce themselves for you.
Good afternoon, y'all. Michael Loriatis.
Good afternoon, Michelle Hayden.
All right, defense.
My name is Nathan Williams Lemay. Good morning. Afternoon.
Valerie.
All right, and your client, please.
Christopher Saxon.
All right. Does anyone here recognize any of those parties? All right. All right, and other than you all meeting downstairs, standing in the hallway today or yesterday, do you know any of the persons that are on this panel with you? Anyone? Number 12, who do you know? All right, what's your number, please?
31.
31. All right, 12. I was just thinking maybe they didn't know you, but now it appears that they do know you. All right. It's shocking that we don't have more people know each other, because usually there are teachers on with students and they say that's one of my students. One time we had a person on there, like, I know her. She's the current wife. I'm the ex-wife. So usually we have that, but they got along famously. All right. So here's a rule for you all. So whenever you get ready to speak, if you're in the jury box, you don't have to stand, because Brenna will be able to hear you. If you're on this front row, you don't have to stand, because Brenna will be able to hear you. Everybody else, if you can, I'm going to need you to stand when you speak, because this courtroom, the acoustics is not great, and that will help Brenna hear. So can everyone promise me that you'll be able to do that? All right, I'm going to hold you to it, because I tell that to every jury panel. Then towards the end, people are talking to the back and they're not standing, and Brenna's, I can't hear. All right, so the charge in this case is an assault family second offense. And I just want you all to think about that a little bit. And then I'm going to go through some more questions with you all. And then the state and the defense will have a chance to question you as well. All right, this is what I want you to know. When the state and the defense speak to you, they're not speaking about this specific case. They're speaking about hypotheticals. So whenever they talk to you, just remember, it is not about this case. Does everyone understand? All right. Neither the state nor the defense are allowed to speak to you about the specific facts of this case. The only way you're here about what both parties thinks are the facts of this case, if you're on the jury. The other thing I want to talk to you about is an indictment. An indictment is how someone is brought to court for criminal cases at the felony level. Does everyone understand? So let me give you an example. How many people, and don't be shy, and this is for me to see you raise your cards. How many people have ever had a traffic ticket? Tell the truth. Yes. Okay. All right. So I've had a traffic ticket before. And when I received my traffic ticket, it was at the time when the officers used paper, right? So now I think they do it digitally or something else. So when you get that traffic ticket, and let's say it's for, I don't know, not following the yield sign or running a stop sign or running a red light, whatever it may be. When that officer gives you the ticket and prints it out digitally, that ticket is telling you what they're saying they believe you did. Like, I think you ran a stop sign. You're going to have to appear at municipal court on Frio or whatever municipal court it may be. And this is the date you're supposed to appear. And this is what you're charged with. So an indictment is the same thing. It's just telling you, this is what you're charged with. This is the courtroom you need to appear. And this is when you need to appear. Now, just because you accept that ticket from that officer, that's no evidence of guilt. That's not you admitting guilt. That's just telling you what you're charged with and where you need to appear. So an indictment is the same thing. An indictment is not at any all evidence of guilt. You're not to consider it at all as an evidence of guilt. Does everyone understand?
Yes.
Is there anyone who can't do that? All right. Now, the next thing I want to talk to you, some rights that people who are charged with offenses or people who are accused of offenses have. How many of y'all have heard of the right to remain silent? Where are my people who've watched Beretta, Mannix? Yes. I see you, you have. All right. So, you know, Beretta, Mannix, Barnaby Jones, the practice, they always talk about the right to remain silent. Well, anyone who's accused of an offense has a right to remain silent. They don't have to give testimony against themselves. Does everyone understand?
Yes.
Is there anyone here who can't follow that? Now, some people will say, well, I know somebody has a right to remain silent, but I really want to know what they have to say, right? You cannot hold it against someone if they decide not to testify. This is not Bewitched with Mrs. Kravitz across the fence. You cannot do that in a courtroom. Does everyone understand? Yes. All right. Now, the other thing we have is that everyone is presumed to be innocent unless and until the state brings evidence that proves their guilt beyond a reasonable doubt. Does everyone understand? Yes. So what that means is the defense doesn't have the burden to prove anything. The state has the burden. So the defense doesn't have to call any witnesses. The defense can read newspapers, play crossword puzzles if they want to. I've never seen anyone do that, but that's just to express to you that they don't have the burden to prove anything. The burden rests with the state. Now, when I graduated from law school, there was a definition for proof beyond a reasonable doubt. You had to know it backwards and forward. And we felt so great when we learned that. The first jury trial I had, we used it. I knew the definition. The second jury trial I had, guess what happened? There's no longer a definition for proof beyond a reasonable doubt. And I was like, and we learned that and we were quizzed on that, and now there's no definition. So there is no definition. So when I was a prosecutor and when I was a defense attorney, what I would do is tell people what it was not. For example, on the civil side, they have different burdens. One of those burdens is preponderance of the evidence, and that's usually involving cases that involve traffic accidents. But one of the highest burdens on the civil side is clear and convincing evidence, and that's the amount of evidence that's needed to terminate someone's parental rights, to say you can no longer be a parent to a specific child. So that's that burden. Proof beyond a reasonable doubt is a higher burden than that. Does everyone understand? So I want to talk to you about phases of trials. On the criminal side in Texas, there are two phases. The first phase is where you find if someone's guilty or not guilty. If you find someone not guilty, there's no phase two. Phase two is the punishment phase. So if in phase one you find someone guilty, then you go to phase two, the punishment phase, which is exactly what it means. It's where you determine punishment. On the criminal side, someone has to make an election of whether or not, if they were found guilty, they will go to the judge for punishment or to the jury for punishment. The election that someone makes is not them saying I'm guilty. It's just required that they make an election. Does everyone understand? Yes. All right. In this case, Mr. Saxon has said that if he were to be found guilty, he would come to the court for punishment. Does anyone have a problem with that? Or is anyone going to hold that against Mr. Saxon because he's made an election to come to the court for punishment if he were found guilty? All right. Thank you. All right. I want to talk to you about the one witness rule. And when I talk to you about this rule, I'm going to give you a hypothetical. Don't add any facts to it. Don't say, I wonder if it was light outside. I wonder if it was dark. I wonder if it was windy. I wonder what the temperature is. No, I'm going to give you this set of facts. It's a hypothetical. Don't add anything to it. So here's the hypothetical. You have a jury trial. A witness comes to testify. And let's say that witness is Mother Teresa. She comes to testify. And the state asks her questions. The defense cross-examines her. You have no issue with whether or not she's telling the truth. You believe she's credible. You believe she's telling the truth. And that one witness proves every element that the state needs in order to prove their case beyond a reasonable doubt. Does everyone follow me? Yeah. All right. Then the question it becomes whether or not, based upon that one witness, you would be able to find someone guilty. And again, this is a hypothetical. So remember, the person is credible. There's no issue for you about whether that person is telling the truth. You believe they're telling the truth. And she or he proves the state's case beyond a reasonable doubt. Is there anyone here who would not be able to find someone guilty under those circumstances? Okay. Now, the next question I'm going to ask you, which I always have a difficult time asking it, because if a person is here who doesn't speak English, then they're not going to understand what I'm saying. So this is the way I'm going to ask it. Is there anyone here whose English is not your first language? Oh, wow. That's the first time. That's you? All right, number 10. All right, what is your first language?
Spanish.
Awesome. I'm always intrigued by people who speak different languages. And people always tell me, if you can speak Spanish, then you can speak Italian and French. I'm originally from Louisiana, so guess what I decided to take in college? French. And now I'm in San Antonio. I should have taken Spanish, but you never know where life is going to lead you. So have you been able to understand everything? All right, thank you. Is there anyone else who has number 59?
Yes, same answer.
All right, remember, if you're not in this box on that row, you have to stand. All right, Spanish?
Yes.
All right, have you been able to understand everything? All right, thank you so much. All right, the next question I'm going to ask you all is about time constraints. Is there anyone here who has a time constraint? By that, I mean, you have tickets, they're non-refundable, you can't transfer them to me. Is there anyone here who has any type of time constraint? Number 1, what is your time constraint?
Well, my mother is having her 90th birthday celebration on Friday, and I was supposed to travel down there tomorrow.
Okay. All right, and where are you traveling to?
Beaumont.
Oh my. How many children does your mom have?
4.
Does she really want you there? Were you a good child?
Yeah, I think she would want me there,
Okay.
but I'm happy, to serve too. I'm just letting you know, Judge.
Well, I mean, it's the 90th birthday. That's a big one.
Yeah, it is.
All right. Have you gotten her gift already?
Yes, we have.
All right. Who is we? Is that you and your wife?
No, it's me, my brothers and sister.
Okay. All right. Usually guys say we've gotten her a gift, and that usually means the wife got it.
No,
Okay.
we all went in together and got her a gift.
All right. Well, I want to let you announce what it is. It'll be a surprise.
We got her flowers,
Mhm.
and we got her some powder that she likes. Ice
Oh.
powder.
That is awesome. I always tell people, that the best gifts are the gifts that people will enjoy. Well, tell her happy birthday from me and from us. All right, thank you. All right, juror number 24.
I'm flying out to Friday,
Where are you headed?
Mexico,
All right, what are you doing there?
vacation.
Ah,
But I'm a state worker. I'm also, I never get to take time
all
off.
right. So what do you do? What do you do as a state worker?
I work for a branch of CPS.
Oh, okay. I used to do a lot of CPS cases. All right, but we understand. All right, juror number 30.
My wife is 8.5 months pregnant. Due the 3rd of September. She's
All right. And is this her first child? All right. Were you at the other births?
Yes.
Did you pass out?
Yeah.
All right. So she will have you there, and you will actually not be a hindrance. You're going to actually be there to help.
Correct.
All right, because I don't want you passing out. All right. Thank you. Number 29.
My wife has chemo Friday.
Okay. All right. Well, we're going to send our prayers that everything goes well. Thank you for letting us know. Number 37.
My wife and I went to Spain. Early, it's the 6th of September. I don't know how far out this.
All right. You're going September 6th.
Yes.
I just came back. It was a heat wave, so be prepared. All right. What part of Spain are you traveling? Oh, okay. Awesome. Thank you. All right. Juror number 46.
My husband and I are going on a cruise, August 11th.
Oh, wow. That's going to be beautiful. I have a friend now who's posting photos. It's going to be beautiful and hopefully cool.
Yes.
All right. Thank you. All right. I'm sorry. 4.
I am actually in the middle of doing a nursing contract.
Mhm.
And deciding on when we would take it. As
Okay.
early as August 8th.
Okay. August 8th. All right. Thank you. Number 15.
I'm a teacher currently right now, and school is starting back around August 9th,
All right, where are you teaching?
at SAIC.
Okay, I teach at UT. Time flies by quickly, doesn't it?
Oh, yes.
Okay, so that's August 9th. Thanks for reminding me. All right, number 55. Oh, where are you going? Ah, do you have your sunscreen?
Yes.
Okay, all right, thank you. All right, number 49.
I know, I have surgery scheduled for the 17th of August.
All right, thank you. We'll send our prayers. Number 51.
Yes, I have twin daughters that are going to college in Austin, and they're moving days of the 15th of August.
Oh, wow. Which college are they going to? Now, that's gonna cost, right? But you're happy.
Yes.
Are you gonna try to visit every single day? They're gonna have to say, Dad, could you please give us some little time alone? All right, thank you for letting us know. Number 56.
I'll be going to Aruba on August 9th. It's for family vacation.
Ah, that sounds like that's gonna be fun. Thank you. All right, so I think I've finished with everyone in the jury box and over here. So number 64.
I'm traveling to Kansas City with my wife Friday. And we'll be gone a weekend back on Monday. But then I have another trip to travel to Idaho on the 13th of August and back on the 24th.
All right, you're doing a lot of traveling. What are you guys planning on seeing in Kansas City?
My wife's mother is this probably the last birthday we get to see her.
Oh, how old is she going to be?
84.
Okay. All right, thank you for letting me know. All right, anyone else? Okay, 59.
Traveling to Mexico for 2 weeks, departing on the 18th of August.
Okay. Have a good one. Number 61.
Also moving a kid into college on August 18th.
All right, and which child is this?
I know this is.
Okay. I was gonna say, if they were headed to UT, maybe you guys could share or something. All right. Thank you all for letting us know. So I'm gonna tell you all two stories. They're all true. All right. So people always say that this is a great jury system. I've traveled all over the world and studied different jury systems. And each system has something you like about it, then there's some things you don't like about it. I always tell people the system can only get better if people participate in it. And we can't have jury trials unless we have jurors, because that's the key to a jury trial, are jurors. So I want to tell you about my uncle. So my uncle grew up in a small town called Grand Cane, Louisiana, and extremely intelligent. He was pushed forward by his teachers. He's since passed. But during the Vietnam War, they were drafting all of the boys from Grand Cane. So he's like, I'm not gonna pick cotton. I don't want to be a sharecropper. I'm not doing that. So he decided to volunteer to go to Vietnam. And I bring that up to you because our country doesn't ask a lot of us when you think about it. There's no longer a draft unless the law changes. There's a war, you don't have to go fight it. Somebody else will go fight it. They don't even ask you, your country doesn't even ask you to vote in an election. And the only thing that your country really asks of you is to be, you say taxes, that's true, you got to pay your taxes. But other than that, the only thing that your country really asks of you is to show up for jury duty and serve when you call. And when you think about it, going to war, serving off the jury duty, then that's not as big an issue when you think about all the young people who went off to war and who were drafted. So I want to tell you that when you think about, the questions that are going to be asked of you here today. And the other thing I want to tell you is about a friend I went to law school with. and you become very close to people that you go to law school with. So we hadn't seen each other for a while because she decided to do civil work. I always loved criminal law, it was my passion, so this is what I do. And usually the civil attorneys are not in jury trials as much as criminal law attorneys. They're usually in trial every week, every 2 weeks. So she told me she had jury duty. Would I like to go to lunch with her? And I'm like, this will be so great. So she has the first morning, they do general, and they're coming back in the afternoon to continue with jury selection. So we meet for lunch. And it's just like years have flown by. It's like we've been talking to each other forever. And so I asked her, how is jury selection going? And of course, I always want to know, who's the judge? You know, how's the jury selection going? She's like, it's going fantastic. And I was like, never heard that before, but okay, why are you saying it's fantastic? She's like, I'm not going to be selected. And I said, why not? And she said, because it's like law school. I'm on the back row, keeping my head down, avoiding questions. So I started laughing hysterically. And she's like, what's so funny? I said, you're still going to get selected for that jury. And she's like, why do you say that? I said, the quiet ones always get selected. So after the day ended at 5 p.m., I see her. I'm like, hey, how's it going? She's like, I'm on the jury. I'm like, told you. So with that being said, I'm going to turn it over to the state, and then I'll turn it over to the defense. And just remember, if you're not in this box or not on this front row, please stand when questions are asked of you and you have to respond, okay? All right, and I'm going to turn it over to the state.
Thank you, Judge. Good afternoon, everybody. Now the judge has kept you up. So again, my name is Michael Villarreal. I'm along with my partner, Michelle. So who here, when they got their jury card, thought this? Right? I get it. Nobody really ever wants to do jury duty. Every time one of my family members gets jury duty, you get, you know, giving a phone call, like, how do I get out of this? You don't, right? So I appreciate every one of you for coming. I know Mr. Jackson does as well, because without you, we're able to try these cases, right? I use this picture to illustrate what is the purpose of voir dire and what do the state and the defense need from you. So, who knows who this is? Willie, right? Willie Nelson. What does Willie love? And it's in the picture. Smoking weed, right? Willie loved marijuana. I believe Willie Nelson even smoked marijuana on top of the White House. That's above it. So, is Willie Nelson going to be a good juror on a possession of marijuana case?
No.
I'm getting a lot of no. Why is that?
Depends what Steve.
Okay. Oh, you VOIR me. So in the state of Texas, would Willie Nelson necessarily be a good juror on a possession of marijuana case? Juror number 35. You can see it.
Like other side is like, oh yeah, it'll be my.
Right. But does Willie Nelson agree with the laws as it relates to possession of marijuana in the state of Texas? No, right? So he can say, Michael, you know what? I understand the law. I just don't agree with the law, and I'm not going to follow it. And that's okay. This is the one time in your life where you get to tell a lawyer and a judge how you feel, and we don't get to argue back. Right? Don't try this with your spouses or significant others. So we just need to know how you feel about the case, whether you understand the law, and then if you understand the law, if you disagree with the law and you won't follow the law. So that's what we're here for. So some of you might be more visual learners as well, or mathy, left brain with my brother. And need an equation. This is what I like to do. What we're looking for is a fair and impartial juror, so that you can follow the law that the judge is going to give you, and then you're going to base your decision only on the facts that are given to you in trial, right? So you're not going to insert some other thing in there, like I have a bias and I'm not going to be able to overcome. I disagree with the law, so I'm not going to follow it, right? So that's what we're looking for. So As the judge mentioned, the state's burden of proof is beyond a reasonable doubt. I can't tell you what, I can give you a definition for what beyond a reasonable doubt means, but I can tell you what it is. The judge took some of my thunder and she kind of preempted me on it. So what can I tell you? It's not. It's not beyond all doubt. It's not 100%. And again, possible does not always mean that it is reasonable, right? Is it possible that a new alien species came down and invaded everybody and made them commit a crime? Maybe, right? But does that mean that it's reasonable? I think, you know, some head shaking, right? It's not reasonable to think that, right? So beyond a reasonable doubt is what we're and reasonable doubt, it only goes to the element of the offense. So if you have a reasonable doubt that the victim was wearing a blue shirt versus a red shirt, if that's not an element of the offense, so long as you find every other element beyond a reasonable doubt, then the state doesn't make it met its burden. Does that make sense to everybody? Does anybody have any questions about that? So this is another way I like to illustrate this. Who here has dogs? Just by show of cards. Out of those raising your card, who has come home to a situation like this? All right, I'm gonna pick on you during number 4. Tell me what happened.
I just not going to the trash room because I was thinking through it.
Right, were you there to see it?
No.
Do you know what happened?
No.
You don't know what happened,
After I know the aftermath of it.
right? Were there any other dogs in the house?
No.
You have a doggy door? Okay, so you weren't there, but it's fair to say, you know, beyond a reasonable doubt, right, that the dog knocked over the trash can, right? Did it stop significant other? Okay. I mean, is it possible maybe somebody made a key to your house apartment, got in there, just knocked over your trash and left? Is it possible? Does that mean that it's reasonable? Right? So that's what we're looking for. And I use this to illustrate, you don't need to be there to know something happened beyond a reasonable doubt, right? I come home to this situation a lot, especially when I leave food on the our living room table. If there's a bag, I know, even with my 3 dogs, immediately who it was. It's my little corgi Elizabeth. Because when I get home, there's only one of them shaking in the corner. Right? I know who it is. She knows who it is. And she knows that I know who it is. So I just need that to. Does anybody have any questions about the state burden of proof? So these are the elements that the state has to prove beyond a reasonable doubt in this case. To honor about June 15, 2019, the defendant, Christopher Saxon, intentionally, knowingly, or recklessly caused bodily injury to Melissa Saxon by striking Melissa Saxon with the hand of the defendant and having been previously convicted of a female offense. So normally, these types of offenses without that last element is a misdemeanor. So bodily injury, causing bodily injury through an assault. But it gets elevated to a felony when they have a prior conviction. So that's what we're looking at. Just a couple on, we'll talk about just a couple of elements. And I'll break those down. So, well, again, we have to prove that there is bodily injury. And our code defines bodily injury kind of in the smallest form of it as physical pain. Does that make sense? Right? It's not an emotional pain, but the state has met its burden to get hurt. That's what I like to do. Does anybody have any questions about that? Knowing that normally that this is a misdemeanor offense, but because of a prior conviction, it makes it a felony. Does anybody have a problem with that? Nobody? Juror number 43 and juror number 50. I'm right here. Yes. So knowing that normally this would be a misdemeanor case, but because he has a prior conviction, it elevates to a felony. Does anybody have problems with that? Other than the two who raised the card, there's 43, 50. Does anybody else? Juror number 41, and I believe juror number 56. Going. Okay, so. Chair number 44, you have a problem? Anybody else? So talking a little bit about more bodily injury. Does bodily injury always leave a visible injury? Now, do a lot of no's. Can anybody give me an example of what bodily injury or how the state might prove bodily injury? Very number 35, it's in.
Going to like a doctor and like check out everything.
Okay, maybe a doctor, right? Turn number 19.
X-rays and bruises underneath shirts, pants, the day and time with how long the bruises have progressed.
Okay. Anybody else? Turn number 16, right, by the witness, right? So, and we'll get in a minute, but testimony is evidence. So if the victim says it hurt when it happened, that might be enough. And so long as you believe that there was physical things beyond a reasonable doubt, you believe that one is beyond a reasonable doubt, then they say that met its burden as far as that follows. Does that make sense? Is there anybody here who would need to see a visible injury in order to find bodily injury? I'm going to show ours number 37, 43, 50. And what they call your number, you can call it, put it down. 57, 63, 64, 58. Is there anybody here who would need to see a visible injury in order for the state to prove bodily injury? Number 42, 28. Does bodily injury always require medical treatment? No. No. Would anybody need to see evidence of some type of medical treatment in order for the state to prove bodily injury? You could raise your cards. I see 41, 43, 50, 53, 19, 54, 57, 58. Did I miss anything? So intentionally, knowingly, or recklessly. Really, there's also an or between intentionally and knowingly. So the state has to just prove one of these three, intentionally or knowingly or recklessly, in order to prove it. Our case. And I'll go through what the definitions are in a second. So what this means is that there'll be 12 people who are selected for the jury. If 4 people said, Michael, I believe that you proved it intentionally beyond a reasonable doubt. 4 people said, Michael, I think you proved it knowing beyond a reasonable doubt. And the last one say, Michael, I think you've proven it recklessly beyond a reasonable doubt. That is a unanimous verdict. Does that make sense, everybody? You just have to find one of the three. Jury number 46. Okay, right. So you just have to find one of the three beyond a reasonable doubt. So these are the definitions that our code gives us. Our lawmakers like to write things in a way that make it, I don't say more complicated, but like I feel like it's easier. Intentionally is your conscious objective or desire to engage in the conduct and cause the result. Knowingly is that you're aware that the conduct is reasonably certain to cause the result. And recklessly is aware but consciously disregards the substantial and unjustifiable risk that the circumstances exist or the result will occur. I like to think it is pretty in more simple terms. Intentionally. Did I mean to do that? Did I mean to cause that result? Did I mean to do that action, right? Was it my intention? Right? Knowingly, it might not be my intention, but I know what the result is going to be. If I throw something at me, I might not intend for it to be, but I know it's going to hit you. And recklessly is, I mean, a lot of us have heard this from our mothers. You ought to know better. Right? You knew that there was an unjustifiable risk, and you knew likely what the result was going to be, but you did it anyway. Does that make sense to everybody? Does anybody have any questions about the state, the mental states here? How do we know that somebody acted intentionally, knowingly, or recklessly? It relates to the defendant. Number 65, you can stand for me.
By doing it again,
Right, so maybe,
first time.
right,
That would change.
so kind of a repeated action, right? Like you hit him once, you hit him again, you're probably intending to hit him the first time. Anybody else? Right, so part of this is you have to think about, the defense, again, the defendant has a right not to testify, so you might not hear about what's going on through his head. You just have to look at really the facts and the circumstances surrounding the thing, right? It's not like, I mean, who's even hit by a sibling? It should be more Carson. Like, John Stroh with DJ and Jacob. Right, they weren't always like, I'm gonna hit you and then hit you, right? They just go ahead and hit you, right? Is it really reasonable for those facts and circumstances to exist to know that, you know, for me to know that they intended or they knowingly did it, you know, right? You can just look at the surrounding circumstances, surrounding the conduct in order to make that determination. And again, you can't read somebody's mind, they can't read the defendant's mind. So, I want to talk a little bit about family violence. This is a family violence case. So family violence, it's pretty simple. It's includes any act by a member of the family and household against another member of the family. Right, so this is just hurting somebody in your family. This also includes ex-spouses. So it's a very broad definition, includes dating relationships, things like that. But specifically also includes ex-spouses, which children. Does that make sense to everybody? So I guess spend too much time on this. Why is it important for the state to prosecute family violence cases? You learn. Journal 17.
I think they want to prosecute it, hoping that they will stop that friend.
Right? Have you heard of the cycle of violence? Okay. And here's some, yes, number 11, cycle of violence.
Hold people accountable.
Right. Okay. And journey number 66.
Protect the innocent.
Okay. Right, so part of this is about, I think journey number 66 has on this, like the relationships between the defendant and the victim, right? Maybe there's some power and control dynamic. So I want to briefly talk about witnesses and family violence. Where just family violence usually occurs? You're in home, house, right? So knowing those things, who's usually around? Kids and hearing kids. Anything, anybody else? The raise your comments for me. Jury number 69. Neighbors, maybe, right? Jury number 18.
Even based off values.
Right, that's kind of observant. Unfortunately, I can't bring a list of. Jury number 35.
Friends.
So let, jury number 16.
People have cameras.
Some people have cameras, right?
Or devices.
Very true. Sometimes drink could be a blessing or a curse, right? So in this sense, when we're talking about family violence, does it mean that usually a lot of people are around? No, right? Are there instances where you can think of where there might not be anybody else besides the defendant and the victim? Right, so if it's in the house, nobody else lives there, there's no kids, there's no siblings. Who might be around to tell you as a true witness, how many witnesses that they would have? Victim, right? So the state might only have one witness to the actual offense. Does that make sense to everybody? Does anybody have a problem with that? Juror number 50. Any other parts? Juror number 56. And 37. So, in this hypothetical, you have to be robbed. Sorry about it, but I had a lawyer like, juror won't have to apply, just choose not to be robbed. No, you have to be robbed in this hypothetical. So who would rather be robbed in the picture on the left versus the picture on the right? Right, we hear a lot of rights, right? Juror number 65, the left.
If you have to fight them off on this side and this side.
Hold on.
You can see it.
I didn't hear you.
Maybe I can fight them off on this side and this side, if they all get robbed and we don't get anymore.
Okay,
Perfect. Or whatever.
you don't want witnesses. You got where to go. Right, I'm an Aggie, so I wouldn't want to get robbed in Memorial Stadium, but I'd rather, if I had to be robbed in Memorial Stadium, when it has 100,000 people, right? Hopefully it's projected on a huge jumbotron so everybody can see it, right? Because I want every single one of those butt hauled into court if I'm assaulted, right? Or I'm wrong. Does that make sense, everybody? Is that what we get in a lot of these cases? All right, that's pretty unrealistic, unfortunately, for what we. So I know I'm beating a dead horse, but I got one more example on this. How about I put you in? So, you were just very disheartened after leaving today because you were not selected to be on the jury, so you're already kind of in a bad mood. That Michael guy was pretty cool and hang out with him for the next couple days. And you were lucky enough because you got here early to get into the Bear County garage, so you parked in the garage, and nobody else was there. You are headed to your car, there's nobody around, and then you get mugged. This is Bear County, so none of the cameras are gonna work. We don't have that. Who thinks, because you are the only witness on the case, that case should not be prosecuted? Right, so this is to further illustrate, we don't get to choose who our witnesses are. If anybody gets to choose who's around when a crime happens, who gets to make that choice? You're number 16, the perpetrator, right? The person committing the crime gets to choose who's around, when it happens, where it happens, who's the victim, right? They get to make all those choices. We just get to deal with the after network. Does that make sense to everybody? So,
You have 8 minutes and 48 seconds.
these are just a quick way of me getting a snapshot about what we think, and so, it's a scale question. So the question is, if only one person testifies, that is not enough to find someone guilty. So there's 4 options to choose from. You have to choose one. You can't be in between any. It's like a pregnancy. Yes or no on one of the 4. So, 1 is strongly disagree. 1 witness enough is enough, it's believable. 2 is disagree. I will decide based on the testimony. 3 is agree. I want more. 4 is strongly agree. I need more. So again, the question is, if only one person testified, that is not enough to find someone guilty. We fall into category number 1. Strongly disagree. 1 witness is enough, it's believable. I see juror number 10, 7, 16, 17, 18, 19, 20, 21, 23, 24, 25, 29, 32, 33, 34, 35, 36, 44, 51, 52, 56, 57, 63, 61, are you up? You gotta give me one. Okay, 65 and 67. You'd be a 1 or 2.
But also, if they're believable, if you're telling they're believable, then what?
That's what it's saying. If I want witnesses enough, it's believable. Juror number 61. Okay, got one card left. If you did raise your card before and you're in category number 1, just raise your hand. I'll get to you in a second. Juror number 6, 9, 15, 22, 59, and 68. Juror number, I'm sorry, you didn't raise your card, but you had your different. Juror number, what's your number? Right? 30.
I actually, about being I have a this account. I'm the president.
All right, what is your number, miss?
38.
All right, we'll come back to you. Thank you.
Just a second. Who falls in category number 2? Disagree. I will decide based on the text of them. Let's see, 2, 4, 5, 11, 12, 27, 28, 30, 31, 39, 40, 41, 43, 46, 49, 53, 54, 55, 58, 60, 61 is going to be 62, 64, 69, and 70. It falls in category number 3. Agree, I want more. Okay, let's see. 8, 13, 37, 47, 48, 56, 66, 37. Either which one. You're just that important. It falls into category number 4. Strongly agree. Juror number 1. Juror number 4. Okay. Thank you guys. I'm gonna switch. Yeah. Wow, that shouldn't be hard. Question number 2. So what about evidence for a second? Testimony is evidence. That's probably going to be one of the biggest things that you're going to hear from witnesses, right? Witnesses are going to take the stand, they're going to take an oath to tell the truth, nothing but the truth, help from God, and you're going to hear that evidence. And you're going to be charged that by the court that the law is, you are to determine the credibility of the witnesses and the weight to be given their testimony, right? So it's evident, but you get to look at it, you get to dissect it. Is it the truth? You can agree with everything, believe everything that somebody's saying, nothing of what they're saying, or maybe some, maybe some not, right? So again, testimony is evidence. What kind of evidence would you expect in a case like this, an assault family theft? Juror number 4, medical records. Juror number 37. Here's photographs of injury. Juror number 29. Same thing. Juror number 43. Okay, police reports. Juror number 65. Same thing. Okay. Juror number 11. Conversation with friends or family. A conversation with friends or family. Juror number 35.
Yes, some stuff.
Okay. Yeah. Juror number 52.
Victim report.
Victim report. All right. Number 57. Video. A video. Juror number 18.
I didn't hear.
I'm sorry. Work history. Work history. Who expects they might hear from the victim? All right. Okay. Is there anybody here who says, you know, Michael? I might, you might be able to give me an every unreasonable doubt, but I will have to see this particular piece of evidence in order to find something beyond a reasonable doubt guilty of this. Based on what you're telling me, I have to see that. I have to see. Juror number 50. What do you have to see?
I can't see you or hear you.
I guess, yeah, some sort of proof of it happening, like physical proof.
Okay, anything, so what I'm looking like, I have to maybe photograph, medical record. I'm looking for a specific piece of type of evidence you have.
Maybe a recording to that.
Say it
Okay,
again.
maybe a recording of the event. Okay, thank you. Anybody else? Your number 47? You can stand for me. Photographs? Okay. Your number 37? I'll get you right.
Something was fine. Yes.
So that's
Some sort of photo or video or something.
okay. They're recording. Okay. 22.
I agree with some sort of evidence, photos, video.
Juror number 1.
Other witnesses.
Other witnesses. Okay. Juror number 8.
Really, any of these listed photo, video.
All right. So we'll talk about defenses first.
56 seconds.
All right, I'm gonna skip self-defense. Basically, that voluntary intoxication, not a defense. Self-defense. So this is the definition, like a briefly, 56 seconds. So I'm gonna go, what it really boils down to. These are all from Oldham. It has to be reasonable, it has to be proportional, and it has to be necessary. So you have to consider all of these things to determine whether somebody acted in self-defense. It has to be reasonable, it has to be proportional, and it has to be necessary. That makes sense. All right, I'm gonna skip the rest of this, all of these, so sorry. Didn't have any questions for me. I never get questions. During another reason, I have questions statement, but. I appreciate it. I'll make sure. I want to. Thank you. All right, thank you so much for your time. Look forward to spending next couple of day or two with. 47, raising your card.
Maybe no question. And, I do know someone who's been accused of this type of.
Okay, and I think I don't have enough time to go through that right now. And so thank you for that. All right, thank you everybody for your time.
All right, so everyone, I'm going to give you a short break. We're going to come back at 3:15. Is that enough time for everyone? All right, so that means look to your left, like in paper chase, look to your left, look to your right. Remember the person who's in front of you because we can't begin unless everyone's here. And which court are you all in? What floor? Who's the judge? All right, so there are restrooms. If anyone needs the restroom, there are restrooms right near the stairwell. So if you go straight near the straight near the stairwell, on either side is one for females, one for males. And you can follow that up and down each floor, just in case it gets too crowded or anything. All right. All right, everyone, please rise. Yes, you all can leave. We stand for you, but thanks for standing for all of us. All right. And everyone has to leave together, okay? So no one can stay behind. Oh yeah, just give me a second.
Okay.
All right, everyone, please be seated and I will take care of that. All right, ladies and gentlemen, it's something that I didn't discuss with you all beforehand, that I want to discuss with you now. Sometimes you may see people entering into the courtroom, handing paperwork to me. Sometimes that's the clerk, sometimes it's from other courts and I'm helping out with other courts. So just know that when you see me signing paperwork or whatever I'm doing, it doesn't have anything to do with anything involving this case. And you may see people coming through that door, then they look and they're surprised. It's because they didn't read the sign outside the door that says jury trial in session, please do not enter. So just so you know, those have absolutely nothing to do with this case, okay? All right, defense, are you ready to proceed?
Yes, Your Honor. Please, court. Counsel to the stage. Good afternoon again. Just a little light there. Like I said, my name is Nathan Slimane. This is Valerie. And we are here in support of Chris. Okay. Now, Chris is here for one reason. And that reason is somebody accused Chris of crime. That's it. He was accused. Okay. Now, here's something really important we need to keep in mind. Is that in the country we live in, anybody can accuse anyone of anything. That's our right. But if you accuse somebody of something, you're entitled to, if somebody's accused of something, they're entitled to a fair trial. Okay, and that's why we're here. Now, what does it take to accuse somebody of a crime? Let me ask you. What does it take to accuse somebody of a crime?
Person feels like them.
That's about right. Somebody feels like doing it. Why might somebody feel like accusing somebody of a crime, even if they know they hadn't done it? Somebody raise your hand and tell me. Yes, ma'am, number 56. Spite. Okay. Can you give an example what spite might be? Okay. So they might say something that's not exactly true. Okay. Anybody experienced that in their life? I think all of us have, right? At one point or another. Now, is there anybody here, and raise your cards, I'll raise my hand, who's been accused of something that they didn't do? Pretty much everybody. Might be easier to ask, raise your card if you haven't ever been accused of something that they didn't do. Let me ask you, ma'am, how did it make you feel? Sad. Sad and nervous. Okay. Anybody else want to talk about an experience being accused of something they didn't do? How it made them feel? So, what I want to talk to in that regard is this. Chris is here, and the judge talked about this, and the state talked about this, what they call the presumption of innocence.
Now, that's not just something we've heard in the movies or seen in a TV show. It's the core of our judicial system. The presumption of innocence. We hear it, somebody is presumed innocent unless proven guilty beyond a reasonable doubt. So what that means is, if right now, before anybody's heard any evidence at all, or seen any, if the judge said, I want you to go in the room back there, and I want you to come back here and render a verdict, there's only one verdict legally you can come back with, and that is not guilty. And the reason why is this, that presumption of innocence is a legal presumption. It means that it stays with Christopher the entire time from start to finish. It never leaves. He doesn't have any burden to show that he is innocent. Why? Because the law says he's innocent. And I want to point something else out. Chris is not on trial today. I'm going to say that again. Chris is not on trial today. The reason he's not on trial is because the law presumes him innocent. What's on trial is the state's case against Chris. We're not here to evaluate Chris. We're here to evaluate the state's case against it. Now, something happens quite often in this country, and we all hear about it. We hear about someone who goes to trial, is found guilty, convicted, sent to prison, and 5, 10, 15, 20 years later, we find out what? They didn't do it. They had their day in court. They came here, they sat here, they had the state present their case against them, and the jury took an oath, and they decided that the state had met their burden. They were wrong. They were wrong. Right? There's something I hear said a lot during trial, and I hear it from the prosecutors, David Weil. When they're talking to the panel, they say, use your common sense. I always cringe when I hear use your common sense. We all have common sense, but that's not why we're here. We're not here to use our common sense. We're here to hold the state to their burden of presenting evidence of what actually happened. And when I hear use your common sense, I want you to realize and think. What they're saying is, we have point A, we have point C, we have no evidence at point B. So we want you to use common sense. We're not meeting our burden. So I want you to use your common sense.
Okay, I'm just going to check at this point. This is argument, and it's not really relevant for purposes for dire about what the law is.
All right, ladies and gentlemen, jury, you'll receive the law from the court. Objection is overruled. You may proceed.
Thank you, Judge. All right, I'm going to ask a couple questions. I think it's going to get some people talking. Who lies the most, men or women? You got an opinion, yes, sir.
Lawyers.
Lawyers? Men lawyers or women lawyers? Why do people? Why do people lie? Yes, ma'am. It's convenient.
All right, and could you make sure that their numbers are called for the
Yes,
record?
I apologize. Number 35.
Thank you.
Because it can be convenient. Yes, sir. 37. Get out of trouble. Okay, absolutely. People lie because they're scared, or maybe they're worried they're going to get in trouble. What are some ways that people lie? Is an exaggeration a lie? Does anybody not agree an exaggeration is a lie? How about a partial truth? Are you being honest if you're only telling one side? Here's why I'm asking these questions. Judge Boyd up here is a judge. She's got the black robe. She's the judge of the law. She gets to decide how this trial proceeds, what evidence is admitted, what you get to hear, and how we're going to proceed from start to finish. If you end up on this jury, you're the judge of the facts. Your job is just as if possibly more important than Judge Boyd, because as a judge of the facts, you get to decide the credibility,
and the weight of any testimony you may hear, you may decide, I'm not buying it. You may decide, you know what? I'm not gonna listen to any. Or let me jump ahead. This is something really important that I want to hit on. We've all heard the expression that a wolf is probably not the best guard of the chicken, right? We can all kind of understand that. Now, Chris is here because he wants a fair trial, right? Is there anybody here, and I'm gonna ask you, please raise your card. Is there anybody here who, because of a personal experience with domestic violence, or because of an experience with domestic violence, someone close to them feels that they would not be a good juror in this case? Please raise your card. Number 6, 10, 13, 15, 17, 19, 2, 4, 7, 9, 6, 5, 3, 4, 7, 9, 50, 7, 8, 9, 60, oh, I said you in the back, 55, 6, 53, 62, 63, 5, and 60.
What was the last time? What was the last time?
69. Now, my question is directed to the people who just raised their cards. When I say, or when I ask, do you feel like this would not be a fair juror on this case, or be the right juror for this case? What I'm really asking is, can you be fair and impartial? Or does your experience make you unlikely to be able to sit in judgment of Chris and not be affected by your experience? Is there anybody whose answer changes, hearing what I mean by being the right juror for this case? So is it fair for me to say that everybody who raised their card just now feels that they could not be a fair and impartial juror in this case because they could not put aside their personal experience and feelings and just hear the evidence as it may be applicable to Chris? Yes, ma'am.
Barely, I just want people to know, like, I can count the bias. But I think I can.
You are biased, but you think you could be fair. It's awesome. Okay, somebody, I thought it was a couple of cards. Yes, sir.
I didn't raise the first time, but after your definition, I wanted to be in the first group.
I'm sorry, I couldn't hear you.
I didn't raise my point the first time, but after hearing your detail, your explanation, I want to be in the first group. Fit that category.
That you do not feel that you would be a fair and impartial juror because of personal experience. Okay. Anybody else? 65, yes. Say.
Yeah.
Was there anybody else? I might not got, 44. Okay, thank you. And again, none of us here are asking these questions to pry. This process of talking to the panel before we start is called VOIR. It's French, basically means to tell the truth. We just want to make sure that the trial that we do have is going to be a fair trial. Okay, that's now, is there anybody here who believes that despite the presumption of innocence, that Chris, the fact that he's sitting here at this table, about to begin trial, just the fact that he's here and he's been accused, that he's probably guilty? Raise your hand. And it's fine, be honest. Raise your hand if you think he's probably guilty right now. He's sitting here without having heard the evidence. 43, 9, 50, 27. I appreciate the honesty. Anybody else? 44.
Now, I also said that the presumption of innocence means that Chris does not have to do anything to try to present his innocence or to show that he's entitled to that presumption of innocence. Is there anybody who feels that for us to really have a fair trial, if Chris is innocent, he should get up there and he should testify and let us hear his side of it? Is there anyone who feels like he should have to do that? Yeah, please raise your cards up. So number 1, number 2, number 4, number 11, number 12, number 15, number 17, 18, 19, number 2, 3, number 8, number 9, number 35, 6, number 40, 39, 41, 42, and yes, after I call your number, go to the Richard card now. 44, 46, 48, 49, 50, 51, 54, 55, 6, 57, 8, 9, 60, 63, 64, 69, 70. Thank you. Okay. The judge mentioned that there's different systems of jurisprudence and criminal justice throughout the world. And in our system, we can find somebody guilty or we can find them not guilty. There's no option to find somebody innocent. Okay, there are some jurisdictions, I think Scotland is one, if I'm wrong, judge, tell me, that actually allows the jury to come back and find someone actually innocent because the person's on trial. Again, Chris isn't, it's the state's case that you're here to evaluate. Now, when we say not guilty, what we're saying is that the state did not meet its burden to prove beyond a reasonable doubt, above the highest burden that we have under the law. Okay, and that means something. I'm going to explain that a little bit more in a second. But they've proved every element of the offense beyond a reasonable doubt. Okay, if they fail in that, your job is to say not guilty. That doesn't necessarily mean innocent, and I'll tell you why. Not guilty might also mean maybe guilty. We don't know. They didn't prove it. We're not saying it didn't happen. We're not saying he's innocent. We're not saying guilty because they didn't prove it. We're going to leave it at maybe guilty. They didn't prove it. Now, being a juror can be hard. And I'll tell you why. All of us come to court with real life experience. We have beliefs. We have biases and prejudices. We have real life experience that makes us feel certain ways about certain things. Makes us feel certain ways about certain people. This is going to be an emotional case. This is a domestic violence case, right? We all have heard stories or heard experiences. But if you're going to be on this jury and you are sworn to follow the law, what it means to hold the state to its burden is, despite what you may feel in your heart, you may find in your heart, you know what, I really feel like he's probably guilty. But the state didn't prove it. I hate it, but they didn't do it. Your job would still be to say not guilty. That's why it's hard to be a juror, because we have to follow the law. And the reason why we have to follow the law is because the law is designed to make sure that someone who's only maybe guilty does not end up being punished as someone who's guilty. Does that make sense? Now, there's two different ways of looking at that. One way, some people think, you know what? I know how I live my life. If somebody is just accused of something, that's good enough for me. I say, If they're arrested, lock them all up, that's between them and God. As long as we get all the bad ones, it's fine if a few innocent ones get in there. Is anyone who feels that way? And it's okay to be honest, none of us are judging each other. Number 50. Anybody else? Number 65. Now, one of the things that Michael said with regards to this case is that this is an assault family setting, which this ordinarily would be a misdemeanor accusation. Okay, but because what he said, there's a prior conviction for domestic violence, that makes this a felony. Can somebody raise their hand and tell me what they think the word conviction means? Yes, sir. He was adjudicated guilty. Anybody else? Anybody think he's wrong? That can be right. It's not necessarily right. For purposes of enhancing a case to a felony, someone does not necessarily have to have been found guilty. They do not necessarily have to have been adjudicated guilty. In fact, for purpose of enhancement, depending how the case is resolved, a case might actually be dismissed, but still qualify as a conviction for purposes of enhancing it to this level. Is that clear? Now, is probably, I know lawyers don't exactly do that. Is there anybody here, like I said, the fact that this is an assault second offense, the accusation, what the state has to prove is that there's a prior conviction. Does anyone here feel, you know what? That's probably good enough for me. If he did it before, if he did it again, he's probably guilty. Raise your hand and hold them up high. 11, 13, 15, 22, 24, 27, 28, 37, 43, 44, 46, 50, 51, 52, 53. Thank you. Last couple things. Is there anybody here who has never been in a fight before? Is there anybody here who has never been in a fight before? Like physical fight, like a physical altercation? I envy all. Okay, so hold your cards up so I can see. 6, 4, 6, 7, 18, 15, 18, 21, 31. And I'm hoping I'm not talking about last week. I'm thinking any time in your life. 39, 41, 46, 47, 54. It's an interesting question. And the reason why is because when I was young, I was in middle school and high school, I got in fights, got hit on a lot. I'd have fights and somebody would win, somebody would lose. And usually the person who started it is the one who would go to the principal's office, right? When you get sent home, then you go to detention. Times have changed. I had a case recently where there's 2 kids who had a fight on the basketball court during practice after school. They're friends. Broke it up. One kid got hurt, the other kid was mostly okay. They shook hands and went back to practice. That night, the kid who won the fight, police knocked on his door. And they arrested him and they took him to jail. And they said it was an assault. Met the standard. It was embarrassing to the other kid. It was upsetting to the family. And none of them felt like that is the right thing to have happened. This should not have been an assault. There's a whole context to what happened. Just like if you end up on this jury, there's going to be a context to what's here. There's a a song I really like, Paul Simon's, it's called The Boxer. Anybody know that song? There's a line in there. It says, a man hears what he wants to hear and disregards the rest. It's very easy for a police officer or someone who wants something to be true to say, you know what, this is evidence I'm going to zero in. This is a whole part of the story I'm going to zero in. And disregard the rest. As a juror, that's the wrong thing to do. You have to consider evidence. Okay? I think that's pretty much it. Okay, lastly, is there anybody here, if you were to hear testimony, say from a police officer, is there anybody here who believes that testimony from a police officer would be more credible than testimony from someone who's not a police officer? Raise your hand. 4, 5, 11, 21, 27, 3, 6, 2, 35, 52, I got 60, 3. Number, thank you. Let me ask you one more question. In addition to the presumption of innocence, the accused in this country enjoys certain other rights. You have the right to trial by jury, fair trial by peers. They're entitled to a right to remain silent, right against self-incrimination. Like I said, nobody can make Chris get up there and testify if he doesn't want to, or if, as his legal counselor, I advise him to speak for him. There are other constitutional rights, one being the right to confrontation. Does anybody here have any idea what that might mean? A right to confrontation, that somebody's accused of a crime might be confronted. Who might an accuser want to confront in court? Anybody? Yes, ma'am.
Person that's being tried.
Yeah, they're accused, right? So the law guarantees that if somebody accuses you of a crime, you're guaranteed the right to confront that person in court, in front of that jury, and to cross-examine them, to ask them questions, to challenge their credibility, their biases, their honesty, right? Now, does anybody here think it's fair for someone who's accused of a crime to not get the opportunity to come to court and challenge the credibility and the reliability and the biases and the recollection and the motivation of the person who accused? Number 50, you don't think somebody should have that right? Okay, is there anybody here who believes that an accused should not enjoy the right to confront their accuser in front of a jury, to challenge their recollection, their honesty, their credibility, so on and so forth? What are some reasons why an accuser might not come to court to testify? I know I'm going to get some answers here. Raise your numbers. Yes, number. Is in line. Could be. What's a big number 34?
They're scared.
They're scared. Okay, that's very possible. I thought it's on numbers. Pick up for a second. Yes, trauma. Okay, possibly. Anybody else? Okay, so let's talk about scared. Now, the obvious thing, if we watch movies, when we watch TV shows, we see the mocking movies, the witness intimidation, all that kind of stuff, scared to testify. But what are some other reasons somebody might not want to come to court because they're scared? Anybody sat in a jury before? Yes, sir.
Fear of retaliation.
Fear of retaliation, that goes with my mafia scenario. There's something different between the testimony you give to a police officer or a statement you may give to a police officer and the testimony you give when you sit up here.
This is a witness stand. And the first thing that happens when you come in here and testify, judge says, raise your right hand. All right? And they put them under oath. You swear to tell the truth, the whole truth, nothing but the truth. So help you God. What do you think happens if you get up here and say something that's shown to not be true? Anybody heard of perjury before? What happens if you're charged with perjury? Is that a crime? Can you go to jail if you get up here and say something that's actually not true? All right, folks, I'm gonna stop there. I'm just gonna ask one last question. Is there anybody here because of their personal convictions, their faith, their religion, whatever, just feel that they cannot sit in judgment of another human being? Anyone else? 23. I'm not gonna cry, I just want to know. 23, 27, 9, 60, 41, 44, 46. Anybody? Oh, 47, thank you. Is there anybody that's any question? Okay, thank you all very much. All right, ladies and gentlemen, have you wait outside, and then we will bring you back in shortly. Everyone, please rise for the jurors. And excuse me, could the person on the back row please remain? The last person. Stay. All right, and everyone in the box, please take your personal items with you, but everyone, please leave your cards behind. Thank you. Hello. All right. I'd say, with regards to the jurors, what is the agreement?
Right now, just we have one.
Okay, just 1 second. Yes,
24. 29.
just 1 second. Okay,
55. And sorry to go back, 50
oh, no problem.
and 64.
Okay, and what are you all not agreeing to?
We don't know yet. We have, we're gonna
We can go to.
correlate our chicken scratch and see what kind of list we have for motions. And we'll see if the state's in agreement with them. But
Okay, how long is that gonna take?
I don't think more than 10 minutes.
All right, then confirm.
Okay.
We've given the 4 that we want, Judge.
Okay.
So we're just waiting.
So there's no, oh, so you're just waiting for the
There's-
defense?
Yes,
Okay.
Judge, we need to figure out if we're in agreement on those. I need to go back and look at my notes.
All right, thank you.
Thank you, Judge.
Mhm.
Okay.
No, not that one.
How long has he been working this?
Oh, okay,
Yeah.
then yes.
Yes. All right, what's yours?
Well,
Well, let's start with the first one, number two.
Number two,
What's the issue with number two?
number two said that it would hold it against Mr. Saxon if he chose to remain silent, that he would not respect his recommends.
I don't remember him saying that.
I think the question that was asked was, who feels that the defendant should have to testify?
Yes.
Well, said differently, it's the same thing.
Well, feeling and whether they would follow the law are two different things, right?
All right, bring in juror number two, please. Hello, come forward, please. Hello. Hi. You understand that the court gives you the law? Do you understand that?
Yes.
All right. So in the United States of America, defendant is presumed to be innocent. Do you understand that?
Yes.
And do you understand that a defendant or someone who's accused of an offense has a right not to testify? Do you understand that?
Yes.
And do you understand that you can't hold it against an accused if they decide not to testify?
Yes.
All right. In this case, would you hold it against Mr. Saxon if he decided not to testify?
No.
All right, thank you.
Your Honor, may I ask a couple questions?
Yes.
Okay, ma'am, the reason I asked a question is earlier when we were doing voir dire, I asked the question, does anybody here feel that Chris should have to testify and give his side for this to be a fair trial? Do you remember saying that? Can you explain what you meant by that?
Well, there's always two sides to a story, so.
Correct. So my question is, if Chris decided to not testify based on your early answer, that you feel like he should have to, would you hold that against him?
No.
Thank you.
All right, thank you.
Thank you.
Defense.
We'd still move to strike the cause.
All right, that'll be denied. Who's your next person?
Number 4, for the same
And-
reason.
All right, could you bring in number 4?
Judge, and if I could just put on the record,
Yeah.
when you did your portion of the voir dire, as you just did with this juror number 2, nobody raised their cards. And so I think we're gonna run into an issue. There are multiple people here who have said that their feelings about something versus having that feeling and disregarding the law are two different things. And so I just I have a concern that we're going to be bringing every single person in.
How many people are on your list?
I can count them.
Yes, what are the numbers?
2, 2, 4, 11, 5, 12, 13, 15, 17, 19, 22, 23, 27, 28, 20. We're ready to get rid of 29, 35, 30, 43, 36, 43, I'm sorry, 41, 42, 43, 44, 46, 47, 48.
And are these all related to the testimony issue?
Some of them are, others, there's.
Okay, which
there-
ones are related to the testimony issue?
Regarding Christopher remaining silent.
Regarding your question where you're asking them how they feel about testimony.
We already did 2, 4, 11, 12, 15, 17, 18, 19, 22, 23, 28, 35, 36, 39, 41, 42, 44, 46, 48, 49, 51, 54, 56, 57, 58, 59, 60, 63, 68, and 70.
All right. So each party asked for 30 minutes for voir dire. I gave each party 30 minutes for voir dire. State with regards to those jurors. I'm assuming the defense, are you asking that they be stricken for cause?
Yes, Judge.
All right. State.
On a wholesale, we would disagree that the answers and responses were qualified and amount to challenge them for cause. I believe he listed jurors number 42 and 47. We previously asked, I believe, that we could have by agreement excuse them. But absent those two jurors, we believe that the standard has not been met based on the question.
All right, so state you're in agreement to 42 and 47. Is that true?
Yeah,
We're in agree 42. I'm sorry.
42 and 47.
All right. All right, defense, with regards to your objection for cause to the jurors that are listed, that will be denied.
And I just want to be clear for the record. All of these jurors were asked if they felt that the defendant should have to get on the stand and testify. Essentially, in my opinion, denying him his right to remain silent.
Thank you. Who else do you have?
We can go on to, there's a number of people who said that they had personal experience with domestic violence, either as a victim or somebody close to them, and they felt that they could not be fair and impartial.
All right, what are those numbers?
Number 6,
Mhm.
number 10, number 11, number 13, number 15, number 17, number 19, number 22, number 27, number 35, number 36, number 43, number 44, number 47, number 49, number 53, number 56, number 57, number 58, number 59, number 60, number 62, number 63, number 65, and number 69.
All right, so you all agreed on 13. I thought 13 was previously excused, but you agreed to 13 and 19. Is that correct?
Yes, Judge. And I could respond to when the court's ready about the remainder.
All right, the court is ready for your response.
Your Honor, I believe that this question was initially asked because of your experience with domestic violence, you cannot be a good juror. That in and of itself, I think, is a very ambiguous question. And the responses, obviously, we had a large response to those to that question. It's ambiguous at best. I don't believe that it rises to the level that it is that they cannot follow the law on a particular issue when the defense has a right or entitlement to rely on, or relates to has a bias against any particular witness or defendant in this case. And so based on all of those things, it was not fleshed out in order to rise to the level for a challenge for cause. And so we would object to the being challenged.
All right.
May I make?
Excuse me, oh, just 1 second. Ms. DeMoss?
Yeah.
Are you able to find the question that was asked for the defense,
On
asked by the defense?
I can look at
And whether or not the question was whether or not,
the domestic violence.
yes, whether or not they thought they could be a good juror.
Okay, I'm going to ask you to please raise your card. Is there anybody here who, because of the personal experience, domestic violence, or because of an experience with domestic violence, someone close to them feels that they would not be a good juror in this case? And then you want me to list the numbers?
No, just that question.
And then there's a follow-up question.
Is there a
Okay.
follow-up question?
Okay, then hold on. Okay, then he says, when I say, or when I ask, do you feel like this, you would not be a fair juror on this case or be the right juror for this case? What I'm really asking is, can you be fair and impartial, or does your experience make you unlikely to be able to sit and judge them? Is there anybody who? I have changes hearing what I mean by saying the right juror for this case. So is it fair to say everybody who raised their card just now feels that they could not be fair and impartial juror in this case because they could not put aside their personal experience and feelings and just hear the evidence as it may be applicable to Chris in this case? And then he asked 35, I think it could, and she said, I think I could hear it fairly. I just want people to know I am biased in the first place.
Okay. All right, thank you. I'll hear your argument or defense.
Judge, very simply, everybody who answered in response to that question said that because of their experience with domestic violence, they could not be a fair and impartial juror, hear the facts for themselves, and make a fair judgment of Chris. That goes directly against the presumption of innocence. And we even heard from 35 that she's in fact biased. So.
But that's not with regards to the other jurors that you've listed. Because the only person who responded according to the court reporter's readback, and if I'm wrong, let me know I'm wrong, but the only person who responded was juror number 35. And also what I have is jurors 10, 44, and 65. Nobody else responded.
I have.
Do you want me to go back and look? There were numbers, I just didn't read that part out.
Okay,
Okay, let me find it. Okay, yeah, the only other ones after that is number 10, number 65, and then number 44.
That's what's in my notes.
I also have I have 10, 11, 35, 44, and 65.
All right.
That's what you have also.
You might have that for- I have 44 as the last one on that question.
Not 55
No, well, 65, yes, and 10.
and 11.
I don't have 11.
All right, so this is what the court is going to do with regards to jurors number 10. I'll grant the defendant's request for cause. Number 44, I'll grant the defense for cause, and number 65, I'll grant the defense for cause. Could you bring in juror number 35, please?
Judge, this is me on the record.
Yes.
Did you have our agreements on that list?
Yes,
The ones that we could agree to as well.
yes.
Okay.
Hello. Hi. Juror number 35, there was a question about whether or not you can sit on this case. And you had mentioned that you wanted to let both sides know what your experience was.
Right.
Right, so do you believe you can be fair in this case and base your decision on whether or not Mr. Saxon is guilty or not guilty based upon the evidence you hear in this court and only the evidence that you hear inside the courtroom?
In my heart, I can. And like, I just wanted everyone to know, so it's not like a surprise later.
All right, thank you so much for sharing that with us. The state or the defense may have a question for you.
Yes, ma'am. I just have a couple questions and I have to ask this because you responded twice when I asked the question. Do you feel as if you had an experience involving domestic violence or somebody close to you involved in domestic violence that would make you not a fair and impartial juror? And you responded at the time that yes, you felt you were biased and that you would not be a fair and impartial juror. And what I mean by that is can hear the facts for themselves and not be affected at all by your own personal experiences. Are you telling the court that you can hear the evidence without any consideration of your personal experiences and being biased by them?
Yes, I think I can. It's just when I heard you, I think I might have misheard you. In my head, I was gonna try to clarify it later, but I would rather you know and then figure it out if you want to ask more than just like, oh, surprise, you know?
I appreciate that, but I need to know, and the judge needs to know, is if you think you can. Are you
At this point, I believe our answers, we're gonna check if this is voluminous, ask and answer, and we have an appropriate response from this. We're not.
All right, you can ask a final question.
I just need to know, you can or you think you can.
I can 100% sure.
Okay, thank you very much.
All right, thank you so much.
Anything else?
No, that's all.
Thank you.
Thank you. All right, you'll be back though, okay? Don't leave. All right, thank you. All right, defense.
Based on our earlier response, we've still moved to strike the cause.
All right, that'll be denied. Is there anyone else?
11,
What's with regards to number 11?
same response. They said twice, they raised their card saying that they would not be a fair and impartial juror because of the previous experience with,
You ruled on this, Judge, wasn't in the record. Brenda went back and looked. Juror number 11 did not answer.
Yes, the court has called up the numbers that the court was aware of and based upon the what was read by the court reporter. The court is going to deny your motion to strike for cause on 11.
okay, Judge, just for the record,
Sure.
my notes, my co-counsel's notes, defendant's notes all indicate that this individual responded that they would not be a fair and impartial juror. I don't know the harm in just bringing the person up here briefly to ask them if that is in fact their answer. We're risking somebody going on the panel who has said that they cannot be fair and impartial.
And just so the record can be clear, I'm not specifically going solely on my notes or anyone else's notes. I'm going on what the court reporter has read into record. So the strike for cause with regards to number 11 will be denied.
Okay, Judge, defense would request the opportunity to question juror 11 on the record.
Judge, he had his 30 minutes for voir dire. Can the state bring in? I mean, at this point, we've been a lot of time. The court made it abundantly clear at the time that we were selecting and instructed both the state and the defense that we have 30 minutes apiece. That on the record during our 30 minutes, we needed to establish challenges for cause and that the court does not bring up every single person that just wants to be brought up.
All right. And the court will note for the record that the court asked both parties how much time they wanted for voir dire, and both parties said they wanted 30 minutes each for voir dire. So that will be denied. Who else do you have?
On that question, that is everybody.
Okay. Is there anyone else you have, counsel?
Yes, Judge. With regard to the question, that is anybody here feel that Christopher is probably guilty just because of the fact that he was arrested? Jurors 27, 43, 44, and 49. This goes against his presumption of innocence.
All right. Can you bring in juror number 27, please? And 44 has already been, I think you all, the
Did we
defense for
excuse-
cause has been granted on 44.
Okay, I missed that.
No problem. Hello.
Hi.
How are you doing this? We're close to maybe getting to this evening, but how are you doing?
Fine.
All right. I just have a question for you, and then the state of the defense may have a question for you, okay? Do you understand that when someone is brought for trial, remember how I was explaining the indictment process and everything?
Yes, ma'am.
All right, do you understand that the defense doesn't have the burden to prove anything?
Right.
All right, and do you understand that everyone who's brought in for trial, they are presumed to be innocent?
Yes, ma'am.
All right, there was some concern because maybe you said that you think someone may likely be guilty.
Yes,
Do you
ma'am.
remember saying that? All right, so do you understand that as Mr. Saxon sits here today, he's presumed to be innocent?
Yes, ma'am.
Are you able to follow that? And that's either yes or no.
No.
All right, okay, thank you.
Mhm.
You're excused.
Okay.
Just wait outside for us.
Thank you.
State,
I believe they're challenged and we have no objection.
all right, challenge for cause 27 will be granted. Could you bring in number 20, 43, please? Hello. Hi. All right. Did you understand that the state has the burden to prove this case?
Yes.
All right, beyond a reasonable doubt?
Yes.
And did you understand that everyone who's accused of an offense are presumed to be innocent?
Yes.
All right. And do you understand that as Mr. Saxon sits here today, because you haven't heard any evidence, he's
Mhm.
presumed to be innocent? You understand that?
Yes.
So if there were no evidence presented right now, and if you were on a jury, then the verdict would be not guilty. Do you understand that? Because you will not have
I-
heard any evidence.
I do understand.
All right. So the question becomes, knowing that, are you still presuming him guilty?
Yes, only because of because of what we were shown in my experience, you know, I feel like I would be.
Okay, thank you.
Thank you.
State?
I believe it's their challenge for cause and the state would have no objection.
All right. All right, then that person will be removed for cause. Could you bring in 49?
That was 43, right, Judge?
Yes, that was number 43.
Well, we're done. Can we just go over agreements, do the disputes?
Oh, yes, we will.
My note taking has been atrocious.
Hello.
Hi, ma'am.
Hi. All right, I just have a few questions for you, and then the state and the defense may have questions for you. Okay?
Sounds good.
All right. Do you understand that the state has the burden to prove this case beyond a reasonable doubt?
Yes.
And do you understand that the defense doesn't have a burden to prove anything?
Right.
And do you understand that anybody who's accused of an offense and they decide to go to trial, they're presumed to be innocent?
Yes.
And that cloak of innocence is with them until and unless the state proves their case beyond a reasonable doubt. Do you understand?
Yes.
All right, there appear to be some concerns about some of your answers. And if this is an exam, whatever you say, you will get an A+, all right? So, with regards to Mr. Saxon, are you able to presume him to be innocent?
Yes.
All right, and defense?
Yes, ma'am, thank you. The question I have is based on your response that you gave earlier to a question that I had asked. Is there anybody here who believes that Chris sitting here, the fact that he's been accused and he's sitting here in court is probably guilty? And in response to that, you raised your card as indicating, I assume that you believe he's probably guilty.
I did, and I have family who's been victims of domestic violence, so I did have that bias. If I were picked to be on a juror, I can 100% make sure that I am fair and impartial, but in this moment, I do have a bias.
You do have a bias.
Yes.
Okay.
But if I were to be picked, I can 100% be objective.
Can I ask what you mean by you have a bias?
Well, if somebody has already been convicted of something and I think kind of it's fresh right now. My mom literally just left, like ran from a domestic violence case just a month ago. So I have
You have strong feelings.
I have feelings about it. Yeah.
Do you think that those feelings would be part of your decision making in this trial?
No.
Yes.
I have no questions.
All right, thank you so much.
Thank you, ma'am.
All right, defense. Oh, just 1 second. We haven't gotten another number yet.
She said she's still biased. She indicated her immediate family member, her mother's recent victim of domestic violence. I think based on that, there's sufficient concern that she will not be fair and impartial. So we would move to strike for cause based on her statement that she is biased.
I don't know how much more percent you get than 100%, but she said 100%. I can be fair and impartial.
All right, that will be denied. All right, defense, is there any more?
Yes, Judge.
Yes.
With respond to the question, is there anybody here, after hearing that this is an assault family second offense, that Mr. Saxon is probably guilty?
I thought we just did the ones with the probably guilty.
No, Judge. There was a different question. That was just the fact that he had been accused of an offense. This is a question about the fact that whether or not this is a second offense, that he has a prior conviction, that they feel that they could not be fair and impartial. And several more people raised their cards in response to that question.
And who would this be?
11, 13, 15, 22, 27, 28, 43, 46, 50, 51, 52, 53, and 54.
And Judge, my notes indicate that the question was, he did it once, he probably did it again. I don't believe it was a challenge for cause, and I'm not as confident in this, my note taking as far as verbatim as it relates to the question, but my recollection is that it is a probablys, not that they would have a bias against it. They are allowed to consider that evidence in certain cases for, a number of purposes that are codified even within our code under 404B 17. I'm sorry, 38.371, I believe, in the Code of Criminal Procedure, as it relates to domestic violence cases.
All right, so this is what I don't understand. Everybody wanted 30 minutes each for voir dire. And it's general and specific, and nobody followed up on issues that they have. So people saying probably, that doesn't answer the question. And I don't know why anyone didn't follow up, and now it's like we're having a third voir dire. So I'm confused by that.
Judge, the need to question these potential panel members is because of the responses they had to these questions that go to the very foundation of a fair trial. None of these questions are arbitrary or fluff. This goes to, can you be a fair juror? Do
No,
you
I
think he's
mean, I
guilty?
understand what counsel is saying, but I don't understand why, when people are raising their hands, why there's no follow-up. It's just, I don't understand that.
And
Because
Judge-
now it's like we're doing a third voir dire and I'm doing the voir dire. Yes.
And Judge, I would also have for the record, I don't believe that you even gave Mr. Slimane a time announcement. So this information could have been covered in a way that raised itself to a potential challenge for cause He was given time. He did not ask the court for more time in order to explore these areas. And so, you know, it's been detrimental to the state in order, if I could just ask broad-based questions and then bring everybody in, when that was not the instructions given to us, that we need to establish our challenge to a cause on the record during our 30 minutes. We've been at a detriment at this point. We're not able to bring people in.
Judge, I just want to respond. I think that's absolutely absurd. I don't think you can get any more direct than, can you not be fair and impartial? Or do you feel that Mr. Saxon is probably guilty because it's a second offense? They said, yes, that's even the question. That's the bias. There's no need for a follow-up. That's the bias. So we would move to strike all those people for cause because they said they presume him guilty because of the fact
But
that
was
there's a
it
second
probably?
offense. We can have the reporter read it
But
back.
not, yes, let's read that back, Mr. Mon.
What, read me that question.
This was the whether or not the fact that this is an assault family second offense. Who believes that because this is a second offense that he is probably guilty.
Do you remember if it was after you asked the word, what conviction?
It probably was, yes.
Because I mean, more disrespect.
Yes. Oh, everyone can be seated. I'm seated, Brenda's seated, it's fine.
A lower back.
No.
After conviction, but before narrative.
Well, I have, that's why I'm having a problem. Okay. Okay, you say with regard to this case that is this assault family second, which is a misdemeanor accusation. But because what he said, can somebody raise their hand and tell me what they think the word conviction means? And then someone says he was found guilty. And then you talk about it could be dismissed. You say, is there anybody here, the fact that this is an assault family second offense, the accusation, what the state has to prove is that there's a prior conviction does mean, you know, that's probably good enough for me. He's probably guilty. Raise your hand and hold them up. Hi, would you like me to say the numbers, Judge?
Yes.
Okay, 11, 13, 15, 22, 24, 27, 28, 37, 43, 44, 46, 50, 51, 52, 53, 55, then hold on. And then, thank you.
And Judge, I'd just like to point out, when I ask a question like that, the response exhibits the bias, and my motion to strike is based on the response, which was all done within the allotted time. We're
Well-
here because the state is not agreeing to this obvious bias. That's why we're having to call these people back in.
Now, here's the thing, when people are doing voir dire in this courtroom, if you're asking somebody if they probably feel this way or probably feel that way, that's not enough for a strike for cause. But bring in juror number 11. Hello. Hi, how are you doing?
Great.
All right, I just have a few questions for you.
Okay.
All right, any questions that the state or the defense asks you are hypotheticals? It is not about Mr. Saxon. Do you understand?
Yes, ma'am.
All right, so if you were selected to be on this jury, can you be fair and impartial?
I mean, based on one of the questions answered earlier, I'm not sure I can.
All right, so now, here's the thing, we are dealing with not Mr. Saxon, these are hypotheticals. All right, so do you understand that anyone who's charged with an offense is presumed to be innocent?
Yes, ma'am.
And do you understand that the state has the burden to prove their case beyond a reasonable doubt?
Yes, ma'am.
And do you understand that the defense doesn't have to prove anything at all because it's the state's burden?
Yes,
All right, so knowing that, do you have any issues?
I have a previous bias, which is why I answered the question the first time that way.
Well, you say previous bias.
Well,
Let's talk
a
about,
bias. Sorry. Yeah.
let's talk about now. If you are selected to sit on this jury, will you be able to base your decision on whether or not Mr. Saxon is guilty or not guilty based upon the evidence that is presented in this court?
Honestly, I do not think so.
Well, here's the thing, we can't do, I don't think so. It
Honestly,
has to be yes or
honestly, no.
All right, state,
No further question.
defense, thank you.
Thank you, sir.
Defense,
Motion to strike for cause.
No further for.
all right, that'll be granted. Number 15.
Did we skip 13?
Number 13 has already been agreed to.
That's already agreed. Thank you. Sorry.
Hello. Hi. All right, I just have a few questions for you. Okay. Hi, do you understand that the state has the burden of proof in a case, a criminal case, when someone's charged with an offense?
Yes.
And do you understand that that burden never shifts to the defense? And do you understand that the defense does not have to prove anything? Do you understand that?
Yes, I do.
All right, with regards to this case, if you're selected on this jury, will you be able to listen to the evidence?
Yes,
Okay. All right, and will you be able to base your decision on whether or not Mr. Saxon is guilty or not guilty based upon the evidence you hear in this court?
I could, but I also do believe I have a personal bias.
My question is, do you think that you will be able to sit on the jury and base your decision on whether or not he's guilty or not guilty upon the evidence that you hear in this courtroom and nothing else?
Then no.
I'm sorry?
No, then.
Okay. All right, state.
No question.
Thank you. Defense,
Motion to strike for cause.
state,
No objection.
that'll be granted. Bring in juror number 22. Hello. Hello. Hi. Do you understand that the state has the burden to prove this case beyond a reasonable doubt?
Yes,
All right. And do you understand that anyone who's charged with an offense is presumed to be innocent?
I understand that.
All right. And if you're selected on this jury, will you be able to base your decision upon the evidence that you hear in the courtroom?
I will try.
All right. So here's the thing. People don't want you to try. They just want to know when witnesses come in and testify, will you be able to listen to their testimony and base your decision on whether or not Mr. Saxon is guilty or not guilty based upon the testimony that you hear in this courtroom and not on anything else? And when I say testimony, I mean any evidence that's presented.
I guess presented like that, yes.
All right. Any questions from the state?
No.
Defense?
Yes, I have a couple of questions.
So when we were doing our questioning earlier, there's a question that was asked, is there anybody here who believes that based on the fact that this is an allegation of a second offense, is there anyone here who feels that's good enough for me? He's probably guilty. And I have that you raised your hand in response to that question.
That's true.
That is true? Okay. Do you feel that you have a bias that would make it difficult for you to be fair and impartial?
And just 1 second, do you understand that if someone is charged with an assault family second, that the state actually has to prove that it's an assault family second? Do you understand that? So the fact that someone is charged with an assault family second, the state would have to prove beyond a reasonable doubt that it is second assault. Do you understand that?
I understand that.
Okay, all right, defense.
Do you feel based on whatever biases or feelings you have, that you could still be fair and impartial in this case, or would your biases, your experiences play a role in your decision making?
I mean, it would be lying if I said it wouldn't affect me because I've been a victim of domestic violence.
All right, I understand that it would affect you, but really the question is the questions that I've asked before. And the number one question for you to answer is, if you're selected on the jury, will you be able to base your decision upon what you hear in the courtroom? And that's whatever evidence is presented. That's what you will have to base your decision on. So are you able to do that?
No.
Okay.
Nothing further.
State.
Nothing further.
All right, thank you.
Thank you.
All right, defense.
Motion to strike for cause.
State.
No objection. How many more do we have? Switch.
We have 6. Any objection to bringing all 6 of these persons in at the same time? State,
No, Judge.
defense?
Yes, Judge Whitaker.
All right, we're not doing individual voir dire because you all had voir dire. So we're not going to do 30 jurors when everyone's already done their voir dire. So
Judge, I think these are all obvious strikes for cause. We're having to go through this because the state doesn't want to agree to these obvious strikes for cause.
all right, then the court can do it 1 or 2 ways. One, either we're going to bring them in as a group, or we're going to bring this entire jury panel back in. And the jurors that will be questioned will be 28, 51, 52, 53, and 54. And if somebody still wants to strike them for cause, you will do it in front of the panel. So what would you all like to do? Because you all both have already had a voir dire, and it was general and specific. So do you all want to bring in the entire panel and just question those jurors? And those will be the only jurors that will be questioned. So what would you all like to do?
Judge, since it's our motion, I don't agree to either one of those, but if there's no choice, I'd rather bring in this group and ask them about this particular question.
All right, let's bring in jurors 28, 51, 52, 53, and 54. Hello. Hello, everyone.
Okay.
All right. And I think we're just waiting for someone else. So is this everyone?
One more.
All right. Hello. And sir, if you'd like to take a seat in one of the chairs here, you're more than welcome to do so, okay?
Yes, thank you. I appreciate that.
Oh, you're welcome. Pretty soon I'm gonna be saying, good evening, everyone. All right, I just have a few questions for you all, and then the state and the defense may have some questions for you, okay? All right, so remember I told everyone that the questions that were being asked of you were hypotheticals. It's not about this specific case. Does everyone understand?
Yes.
All right. So does everyone understand that anyone who's charged with an offense is presumed to be innocent?
Oh, yeah.
All right. Is there anyone here who doesn't agree with that? Anyone has a problem with that? All right. So then the next question I have for you, did everyone understand that the state has the burden to prove each and every one of the elements of this case or any case beyond a reasonable doubt? That's the burden of proof. Does everyone understand?
Yes.
Is there anyone who has a problem with that? Right. Does everyone, and I'll take by you not saying anything that no one has a problem with that. Does everyone understand that the defense doesn't have to prove anything? All right. Does everyone understand that the offense here is an assault family second? Does everyone understand? All right. Now, when you hear that, does everyone understand that if someone is charged with the offense, and again, we're speaking in hypotheticals, of an assault family second, that means that the state must prove beyond a reasonable doubt that there was a previous assault. Does everyone understand that?
Yes.
Okay, so they have to prove it at this time that there was a previous assault.
Yes. Does everyone understand that?
Yes.
And it has to be done proof beyond a reasonable doubt. Even that is proof beyond a reasonable doubt. Does everyone understand that?
Yes.
Okay, so everyone's shaking their head up and down, so I'm assuming that that means you understand. Now, so here's my next question for you. And remember, I told you that in order to have a jury trial, we need jurors. Each of you, if you were selected on this panel to sit and hear the evidence in this case, would you be able to base your decision, whatever that decision may be, would you be able to base your decision on the evidence that's presented in this case, not on some sort of outside influences? Because sometimes people want to know more information and think they should get more information, but they don't get it. They just get what's presented in court. So in criminal cases, what ends up happening is that witnesses are sworn in to testify. They testify, that's evidence. There may be exhibits that are admitted into evidence. If they're admitted, then that's evidence. So is there anyone here who cannot, if you were selected to be on a jury, cannot listen to the evidence in this case and make your decision based upon whatever evidence is presented? Is there anyone who feels like they cannot do that? You can do that?
Yeah.
All right. Okay, so by your nodding, I'm taking that there is no one here who would not be able to do that. All right. Next question. Sometimes people want to hear certain things from certain people, but remember what I've told you, I will give you the law. Does everyone understand that? Right. So each of you, and what is your juror number, Miss?
52.
Juror number 52, would you be able to give Mr. Saxon a fair trial if you were sitting on this jury?
Yes.
And what is your juror number?
28.
Juror number 28, would you be able to give Mr. Saxon a fair trial if you were placed on this jury?
Yes, ma'am.
And what is your juror, sir?
51.
All right, 51. If you were selected to sit on this jury, would you be able to give Mr. Saxon a fair trial?
Yes.
All right, and what is your number?
54.
Juror number 54, would you be, if you were sitting on this jury, would you be able to give Mr. Saxon a fair trial?
Yes.
And I'm sorry, sir, what's your number?
53.
Juror number 53, if you
Yes.
were, you would be able to be fair?
Best deal.
All right, thank you so much. All right, any questions from the state?
That's time.
Defense, any questions?
Just one question.
Yes.
Folks, the reason that we wanted to talk to you again was there was a question I was asked about the fact that Mr. Saxon is charged with an assault family as a second offense. Is anyone here feel that the fact that he's charged as a second offense, that's good enough for me? He's probably guilty. And my notes indicate that each of you raise your hand, said,
It would weigh in the back of my mind.
okay. Yes, sir.
I'd kind of go along with
What does that mean? sir?
that. He
Did it once, probably did it again?
Yeah. Yeah, DWI, one's probably gonna get a second.
And your jury number two?
53.
Here's your number.
20.
Man, you're 52.
52.
You had raised your card, you said the same thing. Has it changed?
Well, it was like the second charge has to be, the first one has to be proved. So he's not been found guilty of one already, correct?
No,
We don't
just
know
let me stop you.
That's,
This is the thing. These are all hypotheticals. This is
I'm
not,
sorry.
yeah,
I'm
this
sorry.
is not about this case. So
Correct.
anyone who's charged with an assault family second, the state has to prove that they have a prior charge of an assault. So it appears that the questions that are being asked, I don't know if you're attributing this to Mr. Saxon. I don't want you to attribute it to
No.
Mr. Saxon because it's hypotheticals.
It's hypothetical, but it's just the language of that second element. It makes it sound like, okay, there's the conviction first, and then we're adding a second conviction to give you the 2 DUIs in a row. And if that's not what it's saying,
The state would have to prove beyond a reasonable doubt that there has been a prior conviction or either a prior deferred or some for an assault family second.
okay, thank you,
So with that understanding,
thank you.
If there was conclusively shown that there had been a prior, is that enough for you to decide? I don't need to hear anything else. He's probably guilty here too.
That's, excuse me, we're speaking in hypotheticals and that sounds like a commitment question, which is not allowed. So just make sure that the question is hypothetical defense.
Thank you, Judge. So I guess in a hypothetical, if there was a showing that there had been a prior conviction, which does not necessarily mean like the judge said prior finding guilt, would you still be able to hear the evidence fairly with regard to the second incident and be fair and impartial without taking into consideration elements without being biased by the fact that there had been?
Is there any confusion? All right. Let me help you all. All right, so if someone is charged with an assault family second offense, I think everyone here, do you understand that the state has to prove a previous assault and that has to be proved to you beyond a reasonable doubt? Does everyone understand that?
Yes.
All right. Now, then for a current assault, the state would also have to prove that assault beyond a reasonable doubt. Does everyone understand?
Yes.
All right, so there is no, they're convicted, previously convicted or placed on deferred adjudication for a previous assault. So therefore, the state doesn't have to prove anything for the current assault. Does everyone understand?
Yes.
All right, so for an assault family second, hypothetically, the state would have to prove beyond a reasonable doubt the previous assault and the current assault. Does everyone understand?
Yes.
All right, does that clear up everything for everyone?
Yes.
And they would have to prove both of those alleged offenses beyond a reasonable doubt. Does everyone understand?
Yes.
And does that clear up everything for everyone?
Yes.
All right, defense?
Nothing further, Judge.
Okay. All right, thank you all so much.
Okay, thank you.
Ah,
Too long.
10 minutes.
But I made it.
oh, you did. Thank you so much for coming down. All right, defense?
Judge, we withdraw our motions on 51, 52, and 54. We would urge motions to strike on 28 and 53. We both indicated that they would still have difficulty being fair and impartial. 53 said you do it once, you do it again. 28 said the prior would weigh heavily in the back of his mind.
So for those responses, 28 and 53 would administer cost.
And Judge, the inquiry really is, having knowledge of this, would you alter or change or lessen the state's burden in proving the assault? I don't think any of those responses establish that. They're allowed to consider it when finding guilt. There's established case law, 404B and 3371 or 3837 Code of Criminal Procedure, and so that's not what the challenge should be for. And so we would object to even those two Rhode Island members being stricken from.
All right, with regard to 28, your strike for cause will be denied. And with regards to number 53, your strike for cause will be denied. All right, who else do we have?
Judge, there's two individuals, 41 and 56, who said they cannot sit in judgment of a fellow human being for religious or whatever reasons.
Okay, that's 41. 41 has already been
41's already gone.
gone. Yes,
Then we have 56.
gone.
56 is gone.
Yes.
Did I skip one?
No, the only other thing is the credibility of law enforcement over federal law.
I think Judge, that's all we have for motions for cause.
All right. Anything else from either side?
Nothing other than, can you just go back over and
Yes.
tell us who's been or who's been excused?
All right. Number 1 is agreed. Number 3 is excused. Number 10, defense challenge for cause. 11, defense cause. 13, excused. 15, defense cause. 19, agreed. 22, defense for cause. 24, agreed. 27, defense for cause. 29, agreed. 37, agreed. 38, excused. 41, agreed. 42, agreed. 43, defense cause. 44, defense cause. 45, excused. 47, agreed. 50, agreed. 55 and 56, agreed. 64, agreed. 65, cause. So just so the record can be clear, the numbers who are gone, either agreed to, excused, or defense for cause are 1, 3, 10, 11, 13, 15, 19, 22, 24, 27, 29, 37, 38, 41, 42, 43, 44, 45, 47, 50, 55, 56, 64, and 65.
And 14, just wasn't here, right?
Yeah, it's a no show. That's what I have.
Yeah, they were absent.
Was 14 absent?
Yeah.
14 wasn't here.
No, my understanding is that 14,
I think that was.
That was 11.
okay, I was told that 14 came.
11.
I think that was 11.
Yeah.
Okay, so 14 is excused. All right, and let me see where that leaves us. I have us at 53.
52.
All right, let's all count again. I have us at 53. Wasn't 14 excused?
Yeah, we can.
14 wasn't
Yeah,
included
no, I
here.
got it, 53, sorry.
All right, thank you. So we're at 53, and then we always do an alternate, so. Your alternate, each one would get an extra strike, and that'll be between 54 and 59. And defense, you're sure there's no one else you wish to bring up?
I would like to bring up people for the reason of their.
Well, I mean, with regards to the officers, I heard you all saying that, but then you changed your mind on the officers.
Well, Judge, I would like to question people regarding the responses that they would automatically find law enforcement more credible than someone who's not law enforcement.
All right, so why did we just,
We can do it as a group.
well, my question is, why did we go through all of that?
We can let it go, Judge. I had essentially made the decision. I thought we were done.
Okay.
It's fine. It's not a, it's fine.
Okay, all right, so you don't want to call them up?
It's fine.
You sure?
I'm sure.
Okay, all right, thank you. All right, if you all want to use the jury room to make your selections, you can.
Okay.
Or either state if you want to go back in the offices and allow them to be out here, you can.
Yeah, just sounds very good.
All right, state, go in the offices and then. All right, everyone. Everyone, settle down. All right, these are, Brenda, you're on the record?
I'm ready.
All right, these are the people who are be on the jury: 4, 6, 7, 9, 12, 16, 20, 21, 23, 25, 26, 30. And the alternates are 54 and 58.
Would you mind going through this one more time?
4, 6, 7, 9, 12, 16, 20, 21, 23, 25, 28, and 30. And 54 and 58. Just 1 second. All right, so again, the 12 are 4, 6, 7, 9, 12, 16, 20, 21, 23, 25, 28, 29.
And not 30.
Oh, I'm so sorry. It's almost what, well, it's past 6. So let me repeat it again. It's 4, 6, 7, 9, 12, 16, 20, 21, 23, 24, 28, and 30. Any objections, state?
Judge, yeah.
24 of them.
That's out.
Yeah.
Okay, 4, any objection?
No.
Defense?
No, no.
6, any objection?
No.
7, 9, 12, 16.
No.
20.
No.
21. 23. 25. 28. 30. All right, so those are the 12 jurors who will be on the panel. Any objections to those 12 persons? State. Defense?
No objection.
All right, the alternates will be 54 and 58. Any objections from the state?
No objection.
Defense?
No, you're.
All right, let's bring them in.
Look at the camera. Whoever going to go to, way at the end, whatever they have to look at, and I'm not. Then you break this. Way at the end, just hang on with everybody else who votes. We're gonna be. Keep going. Keep going. Keep going, keep going, keep going. Not everything we get into this. It's over. Vision numbers. Visual numbers. There's no numbers. So now you can say, how does it emotion?
And if anyone needs to, you can sit on this front row.
There's some states up here. So not everything we get is the. There's my room up here in the front. There's a few people that have kids.
All right, everyone, please be seated. All right, I want to thank everyone for your service. The good thing about us being here this late at night that you should probably thank the court for is because it's after 6, you've avoided rush hour traffic. But honestly, I really appreciate you all coming down. Again, as I said before, we can't have jury trial without jurors. So you're probably going to end up receiving a check in the mail for your service. And what's going to end up happening, it'll probably come 2 to 3 months later. And you're going to be, where did this check come from? Then you're going to remember the great time you had in the 187. Or what you can do is you can actually ask that your check be donated. They have a lot of charities that need donations. You can also have it donated if you so choose. That's completely up to you. Everyone, you're always welcome to appear in the 187 District Court. We're open to the public. I always believe that people should know what happens in court, other than you're coming down for jury duty or you're coming down as a witness or for any other reasons. So this courtroom is always open for you to do that. I am going to call the people who are going to be on the panel. So when I call your name, please take a seat. And everyone, please make sure you have those white sheets. Is there anyone who doesn't have a white sheet? All right, so there should be some extra, so please don't take 2. Only take 1 if you need one. And there's an extra one here. All right. So Christian De La Garza. Christian De La Garza. Aurora Leal. Joseph Marks. Tammy Holt. Joshua Valdez. William Hartman. Alfred Guerra. All right, I'm going to try this one. Eileen Brazowski. Brzezowski. All right. Angelo Urabi. Thank you. I promise I will learn how to say it. How do you say the last name? Oh, I was so far off. Thank you. Kenny Autry. John Demotzi. Aaron Cox. Manuel Gonzalez. Nicholas Alanis. All right, so to everyone in the audience, when you are leaving the garage, if you're at the garage across the street, there's a button that you push to get out and let them know that you were here for jury duty, and they will still validate everything for you. All right, thank you all so much for coming. And can I have parties approach briefly, please? No, it doesn't. No, we're not. You all are, both of you all are okay with starting tomorrow at 1? Yes. Okay. Thank you. You're welcome. All right, everyone, please be seated. All right, I want to give you all your instructions so that you can go home and have dinner. All right, so in this courtroom, I have no control over the temperature. Sometimes it's extremely hot in this courtroom. Well, most of the times it's extremely hot in this courtroom. But on the off chance, sometimes it's cold. So if you want to bring a jacket, I always say it's better to have it and not need it than to need it and not have it. There's a thermostat on the side, but it doesn't control anything. I think it's just there as a placebo. You are allowed to bring drinks if you want to. Just make sure that there's a lid on it so we don't get any more spillage on the carpets. We are going to start tomorrow at 1 p.m. I'm going to clear the docket early in the day so that we can start at 1. You're not going to report to this courtroom at 1. Where you're going to report is to the jury room, and Deputy Laura will show you where that jury room is located. I don't expect for this trial to be to have a lot of publicity or to be on different places, but here's the thing. The evidence you will receive to decide this case will be given in the courtroom. So if there's something in a newspaper, if there's something on some type of social media, you are not allowed to view it. Does everyone understand? You're not allowed to go out and do your investigation yourself. You're not allowed to Google any names or do any of that. If you know someone who happens to know about this case and they want to talk to you about it, tell them you're not allowed to. Does everyone understand?
Yes.
All right. Does anyone have any questions about anything before I release you to go with the deputy? Yes.
How many days do you think that was fine?
Well, of course, you know, sometimes juries can take a life of their own, but I'm anticipating Friday, maybe before Friday. All right, so maybe tomorrow or at the latest, maybe Friday. Okay. All right, is there anything else? All right, you're going to end up receiving badges. Make sure you wear those badges at all times. Those badges will signify that you're a juror. So make sure you wear them at all times when you're in the courthouse or near the courthouse so that people won't discuss things around you. Okay. All right. Yes. Yes. Oh, no. Yeah. All right, ladies and gentlemen, we will see you back here tomorrow at 1 p.m. All right, everyone, please rise for the jurors.